and file affidavit, my lord, in opposition against the affidavit, additional affidavit. So the question is required to bring the affidavit.
It's similar prayer, item number 9. I also filed, I appear for respondent number 3 in the back. Hello, plus.
Made to the Lordship. Proceed, the petitioner has already challenged the subsequent development by WPC number 183 2024. This is my Lordship order. Lordship is the copy.
Yes, he told me that.
My Lord.
But then this is a different aspect.
Lordship.
This is a different aspect.
Lordship. But in this
There is a case where there was a direction passed by the Register of Cooperative Society to the effect that unless you remove the bank,
my Lord.
your bank account will be
Freeze.
That is it. And this court says that it's not passing any interim order. However, granting liberty to those other persons, if they are aggrieved, they can very well approach in that respect.
My Lord. In this petition, Lordship, they have challenged an order of 30/11/2023, whereby additional registrar has written to the chairman managing director to remove the bank from there. This page 55.
55.
They are asking for setting aside a letter of 2017.
Oh, that also they have challenged that.
Why? Yes, Mr. Dev, why you are checking that?
My lord, my primary grievance is that, my lord, at this moment, to change the name, it has to be in accordance with Section 12 of the Cooperative Societies Act, my lord. But that there has to be a meeting of the general.
That so is already there in the earlier petition.
My lord.
Why this petition?
My lord, your lordship kindly considers this fact that the meeting of the general body has to be convened by the board of directors. The board of directors, when this impugned order dated 30/11/2023 was passed, was not in existence. So the Registrar of Cooperative Societies had appointed a one-man committee to convene the meeting of the general body to constitute a board of directors. So without the existence of the board of directors, there cannot be a general meeting to consider the change of name, my lord.
No. Under 41(6) they will do it.
Yes, my lord. So once that is our case, my lord. Once the board of directors is constituted and thereafter a meeting of the general body is
So that is the subject matter of the earlier petition.
This is actually, my lord, the first writ petition.
Understood.
Here we had challenged this order directing us to change the name.
So, but when this court is already taking care of your issue in the earlier petition, why this petition is required? Unless you say that some other relief which are not a part of that petition is a subject matter of the instant petition.
Yes,
and
my
then
lord,
you have to satisfy this court as to why this court should issue at least a notice.
If your lord, then in that case, my lord, the order dated 30/11/2023 is wholly without application of mine.
Which
Because
one?
At page number 55, my lord. The managing director has been directed to hold a meeting of the board of directors and to adopt a resolution for removal of the word bank. The managing director cannot do that, my lord. And the board of directors who can do that does not exist.
So your thing is that it has to be done in an AGM.
Yes, my lord.
Not in a board of directors.
The board of directors will convene an AGM where this aspect.
But you don't have a board of directors.
Yes, my lord. So how can I?
So how does this have any relevance?
Nothing, Lordship.
No, nothing you mean.
Nothing,
If
Lordship,
you're
may
that
dispose
way,
this
you are
matter,
not,
my lord.
No, this may be tagged with the other,
Mhm.
why should I take another?
because here, my lord, the aspect of challenge is to the direction to change the name, my lord. The other with petition,
Will close it, saying
Yeah.
that it cannot be now acted in view of the take it just before the AGM.
AGM. Okay,
Yeah.
yes, sir.
then my lord, liberty may be granted that if the AGM decides something else, my lord, and there is a subsequent direction to us, then we may be allowed to approach the honorable court.
Mr. Day, that is the subject matter of the earlier requisition again.
That, my lord, that your lordship has considered in that case that we may be allowed to hold the registrar of
You are saying that tomorrow, in exercise of the powers under 41(6), they will exercise, they will hold the vote. After holding the vote, there will be something which will happen.
Lord.
And you may be aggrieved or may not be aggrieved.
Lord.
And I have to give you a liberty now. How is it relevant? You are aggrieved, very well, you can very well challenge that the subject matter of a subsequent or subsequent cause of action.
But then this order will remain, my lord.
So
This
I'm maybe
direction to us.
clarifying it that this order would not be acted upon in view of the
Okay.
of it. So that is, I take it as her statement and we'll close it.
Lord.
Lord.
My lord.
Yes.
Lord.
The only challenge is to 3011. Remaining you are foregoing.
No, lordship, there is also another order. Your lordship is aware of that, the 2017 order. my lord.
Yes, what is that?
The order issued by the superintendent of police, your lordship. That is at page number 46. It also conflicts the use of the name bank. my lord.
So why you are challenging after 6-7 years?
No, my lord, this had been challenged in a writ petition
Then?
by the employees union.
Then?
And your lordship, by an order dated 13/10/2023, your lordship.
I
had-
said the employees have no business.
Lordship.
Then?
So your lordship had given us the liberty.
I
The-
never gave you any liberty. Show me that where I've given you the liberty.
Paragraph 4, my lord, page number 49. The last paragraph. I read, my lord.
I've not given any liberty.
Lordship, your
I said that this court, however, makes it clear by the instant order, this court has not decided on the right of the respondent to challenge the order.
Yes.
But I'm not given any liberty.
the respondent number 5 has thereafter come before this honorable.
And by this way, for the last 5-6 years, you have able the behest of the Gupta, there. You are instrumental in getting it staged.
Well, actually, this particular writ petition, if I understand, my lord, was filed prior to the one in which your lordship had already passed an order. So, my lord, and
This is another aspect of the matter. Yes,
ma'am.
there is something to look into it as to whether the entire freezing could be kept on going on if they don't hold it. And that is the
your
reason
lordship had
why
given some time, my lord.
I've given them the time.
Yes,
And
yes, we are agreeable to it.
so that is okay. For that, an AGM will be held.
Yes, ma'am.
Now, this particular document of 2017, if it is there, they have not challenged it earlier. And who is appearing for the superintendent of police? So you would not be taking any action now because the cooperative society now is doing. Because now they the one man committee business. Now they are not in a position to change the name of the bank. So unless the one man committee holds it,
Lord.
yes, the
My lord, I think both the matters be tagged together. Man.
Why?
The other one also. Man. These are connected. My lord, they had passed an order freezing the accounts, man. Now that is creating a big problem, man.
Big problem
Well-
because of that. So thereby I have
No,
given
no,
the,
we are, my
the
lord,
problem is to whom?
the entity, man.
Huh?
My lord, at now,
Problem is given to whom?
my lord,
To
to
those
the member account,
member.
member
So
account.
I have given the liberty to those
Yes, madam.
members to approach.
Now, my lord, let me.
So they have to approach in that petition.
Yeah, yes, ma'am. They will approach, my lord. But only thing, my lord, in some banks, my lord, for instance, my lord, I will give their border road workers, man, PRO. Payments are made through that particular branch. Now, these, my lord, laborers, they cannot come by themselves. So that particular branch manager has to come representing them, man.
Right.
My lord, these people are from in one branch, my lord, I'm one instance, my lord, Golaghat, man. Hundreds of laborers are there. They are being paid through this particular bank. Not bank, man, it's a thrift and credit society. Let me correct me.
So could I turn out there, ask the perfect of the report that as to why from 2007 was the- that I can
Cases are going on, my lord.
that I can do. Could I do
Madam-
that? Against why? Against the bank officials, you have not brought to the conclusion of 2017.
It is only, my lord, the relating to the, my lord, only relating to the
The
particular
ma-
word,
Mr. Goswami, the
That
matter is very simple. There was a direction to remove the name of
my
bank,
lord.
and you are still continuing.
No, we are not now.
You were
Now it
continuing
is
and
on
you
the
are,
day, my
and
lord.
there has been this management, that management, every management is going on, but you were
Now
still
you have not seen that
continuing.
already issued a
By
direction, my lord.
taking the
We are
benefit of
hoping,
moving a matter out here and getting a
my
stay.
lord, we are hoping that, my lord, that will take place. AGM will be held and immediately they will take a resolution, my lord. That is what is was prayed for. My lord. But otherwise, my lord,
Already observed all these
yes.
things. The audit.
This
Yes,
is-
you are not dismiss this. Yes, nothing.
I think it-
My lord, I would pray, my lord, that both the matters be tagged together. And we taken up on the next day, whichever is, my lord, I don't know, I accidentally, I have another matter, my lord, actually happened to be here. 20th of March, it is fixed. And we have already made ourselves clear, my lord, that resolution will be taken at the first instance, my lord, once the AGM is held, to remove that. But we are not functioning as a bank, my lord. Let me make myself clear. When we have countless time, we have said before the authorities,
you are not functioning as a bank.
We are-
Very well.
yes, ma'am.
But the fact that you have not kept the bank the last year,
My lord, this time what has happened, my lord? This-
now somebody has closed in upon you, and now you have no other way. That,
My lord, we have asked the department, my lord, you take the responsibility. My lord,
we take it up on
yeah, if the court,
because they
yes,
say that they are going.
yes, my lord, that is fine, my lord. We are agree. We have not objected to that. We have not objected.
I can do at best something. I can appreciate that this is a matter which- which- it's not a- just of notice.
Your lordship has already in that other matter, my lord,
Other matter is a different aspect. The case of people,
that freezing the account. My lord.
here what you are challenging is that action taken in 2017, you have all along not nothing happened. Then there is one direction being passed by them to the effect that the BOD shall quit, which
Right.
the BOD cannot.
Right.
So as the submit, the BOD cannot. Now, in view of the recent development where it has been categorically recorded that they will be doing by way of
Yes,
an
yes,
EGM.
yes.
So what remains?
My lord, it is us
It
who,
is the specific submission which have been recorded in the earlier order that it is not possible to change the name, the name of the society without a dictate.
Yes.
And as such, they are going to
we are also agreeable
so
to that.
under
But-
such how does
My lord,
that earlier order of the 8th register of corporate
my lord, I'll
society
take
have
the
been
instruction. Let it be kept like this, man. Yes, let it kept like this.
at the request of this court. Now, heard Mr. S.D., the learned counsel appearing on behalf of the petitioner, Ms. M.T. Bora, the learned counsel appearing on behalf of the corporate department, the learned hearing of other case. So by this petition, the petitioner herein have challenged a communication dated 1/8/2017 issued by the Superintendent of Police Bureau of Investigation (POSI) to the Managing Director of the petitioner bank, as well as also a communication dated, where's the other one, page
Page
55, my lord.
55, my lord.
Huh?
Page
55.
55.
as well as a communication dated
3011.
30/11/2023.
30/11/2023, issued by the Additional Register of Cooperative Societies (GSF). This court have also taken note of that in a that is in the party, this court had taken note of the submission made by the Corporation Department to the effect that for the change the name of the bank of the business site, thereby to remove the word bank from its name, there is a requirement of holding annual general meeting. And in the same order passed on 12/1/2024, in the party of 2024, this court have also observed that the department, the stand of the Scotland Corporation Department, and also to the effect that the department officer would take steps to complete the ATM within a period of 6 days from the date of the state order, and accordingly fix the matter on 20,000. In that view of the matter, this court did not decline. However, at the request of the learned officer, the matter, the instant can adjourn to be listed along with deputy of the party of 2024 on 20th.
Okay. Give your blessing.
What's the plan? That's open.
Yes,
Okay.
where is the harbor?
Madam, we have all the records.
We adjourn this matter for the time.
Mama,
Yes, did you get that
Yes,
12 one?
Yes.
It is in fact a part of it as I see in the internet.
Yes, that's
The part of that.
Correct.
That document. It did not disclose that.
Well, that is a letter, my lord. I also could not find out, right?
Found that
I could not find it. They might.
you're going to
The two judgments I have brought, my lord. Two judgments I have brought. Unitech and that, my lord. Unicorn. And
My lord, Hero Motorcorp.
These are my lord, two different aspects. Lordship may otherwise take this the whole one. If your lordship is.
Only uniform para 48 color.
How do you claim that this step A? How do you take step A to step step A? What is this step B?
One second.
Well, to see the entire document starts from 7/5/2030.
Lord.
And this 7/5/2030 sector B is this
This document. Now this, here again, lordship, annexer A is there. Then annexer B and C till D is there. In this document, that the document they have annexed till D is there.
Is it the steel and rolling?
Yeah,
is steel and
because there are two things. One is cement factory, one is steel and rolling. They've clarified what are the machineries required there and which will be included, which will be excluded.
But how do you take this first that document with the remaining thing? Now kindly see number 4, clause number 4 of the document dated 29/3.
Yes,
Based
sir.
on the definition of payment provided the subsequent clarification the representation of technical comprehensive components were considered and ineligible for company other and total and except. In addition, exhaustive of applicable and ineligible of given. Therefore, prior to this, whether there was any definition of plant and machine,
Planted machinery is that I mean this is that policy, NEP policy is there.
any policy, the notification you are referring to did not define plant and machine.
Scheme probably defines.
Huh?
Just give me 1 second, Lord.
No.
There
Plant
was some
and
definition.
machinery was not defined.
There was some definition.
Huh?
There was some. Just give me 1 second.
6-1, my lord, that RDA, my lord. 27-7.
So basically, lordship, the machineries which are erected at the site, that is the definition they have given. The machineries that has been erected on the site, that's 6-1 lordship.
Yeah.
6-1 of the scheme lordship, page 27,
It's 30.
page 30 lordship. In the repetition.
It is okay. In calculating the plant and the cost of industrial plant and machinery
As erected.
as erected at the site will be taken into account, which will include the cost of productive equipment such as tools, jigs, dies, molds, insurance premiums, etc. Now for the insurance premium, I think they have another
Scheme is, another scheme is,
insurance scheme,
scheme is there. So insurance subsidy is there. So
insurance subsidies.
Yes.
But for the calculating this is the, but where is the definition of plant and machinery?
they haven't defined. They have only
So
said,
wouldn't that be that the definition has come now?
I mean, broadly they have stated, let's say plant and machinery, broadly they have stated that plant and machinery erected at the site. On the site, the machineries which have been erected, those will be
But
taken.
you can see from Annexure C,
Sure.
which have been, although it have been partly impugned or something. It includes two types of machinery, which are included and which are not included.
Correct.
Included are the machineries which
Part of
are
the
required for the purpose of
manufacturing.
running the plant and machinery. And excluded are those machineries which are in the periphery.
storage, the factory shades, those kind of things. I mean,
So therefore, why I am asking, what's the definition of plant and machinery? Did it come for the first time now in 2013?
the lordship, this in fact lordship broadly defined. Okay, if your lordship takes it in a broad sense, the machineries those are erected there. Lordship in another
So
scheme,
if I take your subject, then in that case, lordship, it has already been defined. And thereupon,
they have clarified.
they have clarified or they have reduced.
They have clarified it Lordship, because lordship has seen that clarificatory note they have written why it has been done. So it gives a object why they have done it. They have done it because there was a confusion about the as your lordship has rightly pointed out, it was not properly defined. It was a little bit vaguely defined. So the clarity they have brought in with those. That is my answer. Because
So if there is a clarification, it will date back to the date of the.
no, this is already there. So only they are clarifying. So it will date back to the scheme. Scheme is
It is
2007.
of 2007.
2007.
If it is a clarification.
Correct.
Therefore, I specific question to you as to whether, because in many other schemes you see, there is a proper definition of a particular plant and machinery. Or
Lots.
if it is vaguely done and subsequently it is
Clarified.
correctly given, then in that case, would it amount to a clarification of the term?
Yes, sir. It's a clarification of the term because Lord, as I have submitted, Lord, that clarificatory note itself says that it was not properly defined at the point of time. So they are coming with a proper definition. I mean, definition means like they're basically giving an exhaustive list now, saying that these are the plant and machineries which will be included. These are plant and machineries which will be excluded. And there is a reason for that because it's a manufacturing process where actually this scheme is available for the manufacturing unit. So once you manufacture certain machineries which are required for the manufacturing process, you will get it. But for the peripheral thing, as the lordship has already pointed out, those will be excluded. So that is because it's plant and machinery. Because as far as lordship, other things, land part, as far as factory construction, civil construction, those are also included in a different category for the scheme. This is only for the plant and machinery.
What is there in these two judgments, unicorn and?
My lord,
Unicorn lordship, I'll give you the paragraph lordship.
actually, my lord, unicorn paragraph 48, if your lordship see, my lord, that it is
So there are many paragraphs. lordship,
many
not
paragraphs,
only
but
48.
mainly. So this is only because of the
Unicorn specifically says, lordship, that
GST.
it specifically says that if public policy demands, then it can be done. Promissory estoppel will not be applied.
Where?
Unicorn,
Paragraph
paragraphs, I'll just give the paragraphs, paragraph 13 to 15. Then 16 to 20.
Unicorn industry is same. 90 নহয় 20.
What was the issue in Unicorn?
Unicorn matlab in fact matlab the GST act that matlab that is why matlab this is sorry paragraph 48 matlab notice number so and so issued in the present case makes it clear the exemption was granted under 5A. They wanted to some subsequent matlab things concerning additional duties under 95th additional duty of under 38.
Oh, this is the concept of bringing education sets and higher education sets and
Yes.
other sets,
Within the
whereby it was said that there are many high courts. In fact, our high court also said that it is like a piggy bank. You, if the main demand cannot be there, they cannot get the part of the excise tax. And there was although there was an exemption of excise duty, but there was an imposition of higher education certificate. Now, could that be done? That is the issue. I think.
And that was just subsequent.
that
That is subsequently matter.
That is little bit different, Lord.
That is
But the other case, let's say Union of India versus Unicorn Industries. There the aspect of proprietary.
Well, which one?
Hero
Unicorn
Motor
That
Industries
Mobile.
2019,
Union of-
2019 10 SCC.
Very good.
That I have a given for you. I'll just.
And Hero Motor is also there.
There only, Lordship, where this promissory SPFL as far as public policy has been discussed in debate. That
No,
is Lordship,
public
Gawai
policy
is
is different. We are not on the public policy. It is a question of clarification.
Lordship,
Whether that is my therefore the question is,
no, he's,
can you by way of a clarification? You see, although question of why he is thinking on the question of property, he said, take 1A, 1B, and 1C are very clear, which stipulates that I am entitled to these. And on the basis thereof, I have started my industry.
Correct.
Now they are come in 2013. My application was filed on 1911 of February 2013. Now, while they have come up with this, they have reduced my eligibility, which was there under 6.A. And therefore, and on the basis thereof, he is therefore striking on the principles of promissory estoppel.
exactly, Lordship, exactly. Lordship, this case specifically decides on that issue.
Which one?
This if Union of India versus Unicorn Industry,
But the-
2019 10 SSC 575.
but
It has also initially it has given exemption, later on the exemption was taken away. Then there was an argument of promissory estoppel against the government. Then this case says that no, it can be done by the government if it is in the public interest and public policy. In our case also, it's a public policy because it's a public money is going. Para 13 to 15 years also. And this case has been followed in Hero Motor Corp.
So are you saying therefore that you are withdrawing it?
No, we are not withdrawing it. No,
This is the case of
no,
withdrawing.
that is perfectly fine. But the principle here is like we are giving a clarification. He is saying that like
The
whatever.
question therefore would be whether it is not the clarification of withdrawing.
No. See, what I am submitting is that in this particular case, there was a withdrawal. That is perfectly fine. I am only submitting on the issue of promissory estoppel, whether promissory estoppel can be put against the government policy. So that is the issue, Lordship. There also, in our case also, Lordship, there was a promise made. We have taken that there was a promise made by this scheme. Now later on, there was a
Scheme provided
yes, Lordship.
on the basis of
On the basis of the scheme, a notification has been issued. Now, thing is that like he's saying, no, you have earlier you have promised plant and machinery will be like this. Now you are excluding this plant and machinery, so you can't do that because you have already promised, so you'll have to keep your promise. But what I am submitting is that because there was a public policy change, public policy change means like it's a public money. Then there was
So
lot
are you therefore saying that there is a change of policy?
not exactly a policy,
So,
Lordship,
Finally,
but the government has
definitive
Lordship, by a notification, government has clarified certain things. Why government has
So if it
clarified?
is a clarification, it is about changing.
The clarification is not. Of course, Lordship, I mean, if the plant and machinery, that promise has been made for I mean, NMOS plant and machinery, and now like you are excluding certain machineries, that is kind of a change in the stand of the government. So whether the government can change this stand or not, once he has made a promise. So that is the case here also. Here also government has actually changed certain things to the extent of excluding certain machinery. So this has been done with some reason.
Let me give you a very clear cut example. You see what section 148 of the income tax. There 147 prescribed that on the basis of having tax, if there has an income having escaped the
Landlords.
you can very good carry out the DS. That's the reason of not
But sir,
the 148 says about the total. Now when the notice was to make the High Court interfere, say that if you are issuing a notice on the basis of respect of particular aspect, just for example, A was the reason. You cannot carry out the reason or other aspects. Therefore, a defense was made to the of the standpoint. Giving it the authority from the date on which the
that is how.
day that our legislative intent was
Yeah.
the reason is that to open up every.
Correct.
So under such circumstances,
Yes, sir.
so therefore, that was held to be good on the basis that it was a clarification.
Clarification.
Is it not? That's the case of clarification.
It's a case of clarification.
And if it is a case of clarification, then there be a change of policy.
No, I mean, not the whole policy change I'm talking about. But as far as little bit of change has been brought in, the change to the extent of clarifying the thing. So whether that will come under this Unicode or not, that is my
Unicode was the case of word of Unicode was the case where it was then what they did, they came up with to saying that to give this amount and of that put it. We made therefore the question is how it work given up. Good day. Yes, the base of well, so it is the case of Victoria.
no, it's not on withdrawal. It's Lordship is perfectly correct. Like it's a case of clarifying certain things. It's not exactly withdrawal.
No, because if it is a case of clarity of an existing case,
Yeah.
then it dates back to that.
That 2007.
And if it dates back there, then where is the
That's absolutely correct.
but how does Unicorn fit it?
The unicorn fit into the extent it in my humble submission is that because initially I mean it obviously it was all along the promise was that plant and machinery. Now plant and machinery was not properly defined. Now later on
Therefore, I am asking whether there was a further coordination or explanation but after 2010.
no there was nothing. As far as there is no other notification.
Now what happens if it's a clarification?
As far as Lordship, government notifications and all, that can be retrospective. That can be retrospective if it is in the public watch.
So they say they that is of which the
But
time
they-
is up.
Now, Lordship, when the matter was examined, this notification is already there on the table. So whether that can be discarded, because Lordship,
So he said it happened which you say last occasion you did before. and for which you are not.
Yes, Lord.
So your case, he says that it is effective. If it is effective, then can you think
Wait, Lordship, it is correct, actually correct that he has gone for commercial production earlier to this notification coming into effect. That is correct. But while examining his case,
the problem arises what the word prospective use understood
that may be what that may be a mistake, Your Lordship. I mean, but intention was not that because
mistake when
because-
authority
because all throughout the intention was because they've applied that Lord. That notification they have applied. Otherwise, they wouldn't have applied had it been prospective. Because they have applied this notification, with the application of the notification, that amount has come. So that intention was already always there that like when it has come into effect and the whatever the claims will come in future, that will be taken into account. That notification will be taken. Into account.
but how do you take care of that? How do you explain this court
So
They-
in my humble
out of
submission,
that particular paragraph where it is
in my humble submission, that may be a genuine mistake because
you cannot say that
because
you adopt it, whatever he said, and I have given you an opportunity to say that I think
I mean all the details have been given by that. Right?
Ah.
So there was no, I mean,
so you say that you are not filing,
Lordship, from
you
the
support it perspective.
I support it, Lordship. Other materials, whatever they have given, all the materials that they and like those are on the record. So I cannot bring.
Tell me, how
If-
did this court that the prospect when it did not happen, can
The
the
Lordship
counsel
has to,
say,
the Lords,
can the counsel say that there was a mistake?
the Lordship,
That is not
Lordship
happening.
has to look into the action that department has taken. Lordship, the department has taken
No,
into
can
account.
this court say anything if the department takes matter? Because how do I expect all others? How to with that very basic
Lordship has to take into account the action the department has.
they have themselves said it.
That is what like I'm saying,
I
Lordship.
can't say anything more than that, but they
That is clearly written. That has been written. But in my humble submission, Lordship has to take into account the action department has taken. They have taken into account this notification that shows that indicates that like it is a retrospective.
how did you earlier settle?
Lordship,
It came in that
the
the
earlier-
scheme came in 2007.
Lordship.
How did you settle from 2007 to 2013?
So that's what like, I mean that clarificatory that annexa itself shows that different agencies were
It is
doing it.
subsequently.
Yes.
How did you choose prior to that? What was your basis of granting? You must have definitely granted somebody.
Yes, yes.
Then
Lordship.
how did you grant?
On the basis of the plant and
What are
machinery,
the materials you have taken into account then?
then also field visits were there. Initially the DICC does a field visit, then it comes to the SLC. SLC looks into it, and after then again if
I know that
correct,
I am
Lordship,
not
Lordship
on
is aware of this.
the procedure.
Yes.
No.
Yes.
What is your basis? What is your basis prior to the date 2013? How did you settle it?
It's
I'm
on the
not saying how. What is the procedure in which you
no,
settle?
it's on the basis of the field visit only, Lordship. Field visit as well as bank appraisal.
But then why you are not? I am asking you how. What is your basis? Come to a finding. Yes, these are the plans and machinery we are going to give it. Did you only include those which were a subject matter of that particular the main plant and machinery, or did you also look into the periphery?
The that Lordship, I'll have to take an instruction on that, like whether what exactly they have done. Because that is not there on because for that like I'll have to scrutinize the whole record, like how they have done. I'll have to see the record, how they have got, because how SLC has done it, that it is difficult for me to.
No, you must have 100% settled prior.
Yeah,
You must have 100% settled
they must have checked.
prior to that.
Yes.
Which are the
Yes.
So if you have settled with others, how did you get? What are the components you have taken for the purpose?
That is what I'll have to, because there was no exhaustive list at that point of time, because they have come only in 2013. So as far as my knowledge is, my knowledge goes, Lordship, I know that like there are field visits done by the SLC team. So SLC team does a field visit and like which are the machines, machineries, plant,
Which are the companies you
those are which are actually used in the manufacturing process.
then if you were taking already there,
But
then
still,
why then they were already taking there? Then why did your district district manager come up with such a phenomenal amount of 74 crores? Tell me,
that is
if you
why
were taking that,
there were some confusion
don't
that
you
was
think that if the submission which he has to make, he is the authority
similar.
because you have made the mistake.
We only have to Lordship what
Therefore, I am saying you had put it at 74 crores.
the DICC Lordship.
You are representing them.
Yes, GM has done it.
So what
Okay.
is your basis?
The basis
Why
of-
did you put it at 74 crores and they made it to 49? Because they made it under 49, knowing it very well that these are the other things on the basis of 25-2. Understood. But why did you make 25? And whether there was any other settlement apart from the petitioner? Because then the principles of Article 14 come into the play. Or did you take any steps for recovery of others if you were taking it to be a clarificatory? Not so easy to put your hand. If we made this, okay, now this has come, this will be, isn't it? Mr. Sayawala?
Yes.
This is that.
the DICC Lordship basically times.
You are representing the TH,
Yes,
so you must be supporting. Why did you make 74 crores?
DICC is a
So
basically
your submission should be limited to 74 crores. Why do you make it?
the 74 crore is the Lordship. It's a recommendatory thing. Ultimately,
Why?
ultimately SLC will decide on this.
SLC is also under you.
Yes, Lord.
Why did you make it 74 crores or whatever may
No,
be?
no, we haven't made 74. We have made it 50. SLC
what-
has made it 50.
Why did you make it 54?
They have scrutinized all these documents.
Why
They
did you form some 54 or
Sir.
58? They have reduced it to 49.
No, they don't, Lordship. They haven't challenged that. They haven't challenged my.
What about other? That is their basic case.
They haven't challenged my.
They need not. Their basic question is, then look here. Earlier, I claimed 120 crores, of which DIC, the general manager, made it 74 crores and giving us this particular amount. And then one fine morning, they, after a lot of people, time has gone, they have given you 14 crores. That's it. Now, on the basis of the affidavit, it is clear that yes, you did it at 74, the DIC, and thereupon the SLC or whatever it may be, they did it at 50.
So, Lordship,
Then they reduced it to 49.
Lordship, 74 is basically recommendatory amount, and out of that 30%. So,
Is what I'm saying, that is the basis.
so
They are
ultimately,
getting 14 because of that. Otherwise, they were supposed to get 22 as per the 74. They are not on that. So what is your basis? If you were doing others, why not him? It is because of your delay this has resulted. So therefore, the question comes as to whether this is reduction made subsequently. I have never understood that he has done something, you reduce it, something, and you can do it. But is it a case of reduction? Or is it taking away certain benefits? In respect to an application filed earlier,
as far as like this particular case is
so
concerned,
that is the problem of not filing an application and putting all your emphasis upon the application.
so because Lordship, they haven't, as far as my amount, initial DICC amount, they haven't challenged that. Because their application.
Why
was-
is the,
No, their
their
application.
basic case is 74?
Yeah.
DIC is 70. Why they are paying me, which accumulated to 21? 30% was 21 or 22. They were supposed to get.
Initially, Lordship,
They gave you only 14 because of 49.
they claimed for 88, then DICC made it 74. Then SLC made it 54. Then Empower Committee made it after the field visit 40 something. Then out of 40 something, 30% is they. That is the
So-
amount.
So what is your basis of coming to 54 or 8? Do you have no reason? We have to put that the industry department.
No, they have explained it, Lordship, here in their affidavit. In that Empowered Committee note, Lordship, that Lordship may kindly have it.
I'm ready.
The Empowered Committee note, Lordship, everything has been detailed. Phase 140, Lordship. Lordship has gone through it. I'm sure Lordship has gone through it, but it has clarified all these things, Lordship, how it has been done, on what is.
No, no. Their basic state, they have taken it by 2. How did you do it?
The Lordship may kindly give me some time. I'll file a court affidavit on these things. How they have calculated. That I.
And not only that, as to whether you are a SLC,
Look.
as well as you are also preparing for the DIC. SLC, there must have been, you have also made recommendations for certain have been given. What is your basis? Or did you? Don't come up with that thing that you have made the test or what is called fit. Have about that. What is the basis of arriving at what is the answer?
Let me have an instance. Because if they have
Don't you think
certain,
with the Ivala that is required?
Hello, but this is there at the page 150, my lord. The ACC has given the note, but he has visited, my lord, here in everything, my lord, and they are ready.
But let us see, because then the question would be whether they are reducing or because are they clarifying? So that is a very important
the Lordship is seeking for the basis.
because there are certain clarifications which are retrospective, can be given retrospective from the date,
Yeah.
or there are certain clarifications which has to be given a perspective.
Right.
The problem otherwise would not have been. I could have very well taken up because of his affidavit where he says that it will be perspective. And how to his court now deal with that particular situation?
And my lord,
Give me an answer. How do I write my judgment?
I understood, Lord. So Lordship, there may be some instructions from the central government that I'll have to fight. If there
There may be, but give me something. Otherwise, how do I say that it is retrospective or it dates back to that when the central government specific affidavit is prospective? See the affidavit.
yes,
yes, Lord,
How can this
that is
court
there.
help you?
my lord, at page 115, 115. Sorry, 116. From 115, para
You
11.
see paragraph number 11
Yes, Lord.
of that. That the averments many are wrong and denied. It is averred that the letter dated in the revised circular does not alter any of the provision and does not violate the principles of consent as alleged by the petitioner. Okay. There has been inconsistency in the methodology adopted by the different states of the including statement for the industrial unit. Therefore, the government had clarification here which will have prospective effect. Now, how do this court deal with this?
I understand.
And when Mr. Sahiwala has pinpointed this,
My humble
or
submission.
give me a good suggestion both of as to how do I write a judgment in your favor with this data.
I
You
have,
are the learned counsel.
my humble submission is that Lordship, they have taken it as a retrospective, but somehow it has
This line was it necessary?
not at all required.
If they have put that line, how did the matter having been heard at length? A question arises in view of paragraph number 11 of the affidavit filed by the respondent number 1 and 2, wherein it has been categorically mentioned that the clarification letter of the circular dated 25,013 and 75,013 with have prospect. In that view of the matter, question therefore arises as to how the respondent authority have taken note of, have settled prior to these communications, these circulars, the capital investment subsidy in terms with the Northeast investment, Northeast
Northeast industrial, industries, industries and investment and promotion.
investment
And promotion code. NEIP.
Mr. A will tell the learned standing counsel for the industries department. But put the specific query as to what is the basis on which the general manager, district industry sector, had recommended $74 crores, 93 lakh 23,434. And thereupon, the state level SL China Apart from
State level
had recommended 58 crores 52 lakhs 82,928.88. In other words, whether these recommendations were based upon the circular of the letters dated 25/2/2013, or were based upon some other aspect which were taken into consideration for calculation of the value of the plant and machine. Mr. M.R. Odhikari, the learned counsel, standing counsel, appearing on behalf of the respondent number 1 in is also directed to apprise this court on the next day on the basis of an affidavit to be filed. As regards the meaning of the word, as regards the
use of
as regards paragraph number 11 of the affidavit so filed. While you respond number 1, if the matter again on 7th of March, the affidavit be filed by 5th of March. You also file affidavit. If you don't file an affidavit this time,
I'll file an affidavit.
you are not filing it.
No, Lordship, this was a detailed affidavit covering everything. Only this aspect was left out because Lordship has raised it. I'll file an affidavit.
Dear affidavit, first of all, you have to why you had you do not normally take up the
No, usually
like
I
this
don't.
and
No,
say that okay,
Yeah, usually we don't, Lordship, but here, Lordship, the scheme was there, the notification was there. Anyways, I'll file it.
that's the people. Yes. What have you found out? Is there a cancellation of the entire contract? Hey,
Oh, my lord. I have called my lord the revenue staff. That the two lakh mandals are there. We have also secured the original record.
What is it?
There, my lord, I have flag in the bunch of documents. My lord, the first flag mark, once lordship will find it, it pertains to my lord NK Patta number 3. There is my lord, and some pages, my lord, I apologize, I could not mark it, my lord, with page number. We received it just today morning. But
You do one thing. What to say? You give him also.
Yes.
And then we hear it after I come back. Okay. Because without him being, without he also in the dark.
now we have also bought all the voluminous records as well as the map. Now, one fact which I find disturbing at this moment is that, my lord, is 250 bighas of land which they have proposed. Now, my lord, the fact remains that in a demand, my lord, that the earlier filling proceedings it has led to nowhere. My lord, it has almost become infructuous. Now, my lord, those 5 persons are claiming 50 bighas. Lordship has made an indication, my lord, last day. 250 bighas. And 250 bighas I have inquired with the last one, they are in the court, my lord, that now there is no land available. All the lands have been, my lord, settled. Now, therefore, my lord, a question may arise, my lord, they have to be compensated. Because there may not be a case of return of land. Because by this time, my
No,
lord,
no, he is in occupation of farmland.
he is in occupation of some land, my lord.
He is in occupation of 160,
58. Yeah.
158.
158. Now,
That is
150,
Patta number 9.
Patta number 9. Now, Patta number 9 is
Now
also
the
to-
problem arises is these 250 bighas which were there in front of the street remain in his name. But he did not pay any use as to be seen from this document.
it was put
And-
to auction.
And you must have gone for auction sale.
Auction and my lord, those auction purchases have also been recorded as Patta rights.
So you did that has already been sold.
Yes, my lord.
But did you issue notice?
That again, that aspect of the matter, my lord.
It is another issue.
Yes.
You make it matter for a
So therefore, my lord, at
But
that,
if he is in possession of a time and there is no alone, therefore I say that is why on the last occasion I did not I gave you because I knew there seems to be something wrong because so much of land is not the state government is always pressurized by court or anyway to have done it. So how if he is in possession of Patta number 9 and Patta number 9 is the land which went to the government.
Yes.
And there is no settlement being made in respect of that. He can be given out there.
no, so therefore, my lord, maximum limit is 250 bighas. 50 bighas is per.
He may not get, he may forego, he may
in
very
fact-
well file an foregoing other.
No, therefore, my lord, since there is no land available there, so therefore 250 bighas minus 150 is the remaining part, my lord, the balance part. That I think we have to compensate.
Yeah, exactly. No, that
If-
was
if-
our,
if no
But
land,
how do you compensate that?
that will have to be calculated.
How?
The formula is there. Formula is
What formula?
the mode of calculation, but that.
Under what to, under what to?
So it is in the ceiling as itself. Surplus.
No. Even land which is outside, can you acquire? No. That is when the matter is the subject matter of challenge. And you yourself say that this is not a part of your land, so you have not acquired that. So if you have not acquired that land, then the question of acquisition in terms with that act does not arise. So the acquisition, therefore, you have to think about the acquisition has to be made in terms with the land acquisition act, which will have a far-reaching consequences again. Now, if the land is not there, can you acquire?
Because by this time, my lord, it has already been settled. This is what I am told.
So it has to be something else. So if you now settle it out with them, that look here, we are going to give you this line, forget about other thing. I think that is a better course of event.
In fact, we have given that
Because
option because
250
one,
because 250 because proposal is forthcoming from their side.
No, it's okay. They are, I think they will be agreeable to this one
for,
fifty-eight
for
or
the
yeah.
balance 92, Malab.
Huh?
For the balance 92 bighas, if I'm allowed to retain 258, 250 and 158 I retain in 9, then I'm further entitled to 92, Malab.
No, you are entitled. How much do you want?
No, I'm concentrating. That's what I'm.
He's only concentrating on 158,
150.
nothing more than that.
So
So-
if that is the submission, I am safe.
So 158, talk it out between you. We will be happy to like it.
19th of March.
Talk it out between you as to whether 158 you are going to give and he forgoes all his rights in respect. So patta number 9 becomes his. That is the only win-win for the government. Otherwise, the government will have a huge problem at this.
Yes, yes.
Because the acquisition, there cannot be in terms with this. It will be an acquisition. Now, acquisition has to be made again. You don't have a notification. There has to be, how do you calculate?
Yes.
So it cannot be by any law saying, so it has to be outright purchase on the value. So that will make it huge. So if they are agreeable to 158, they don't,
Yes, yes. 158. The part and parcel of land which they are possessing right now. In fact, their names are also reflected, but somewhere also it's a part.
no, it's okay, whatever name, but you settle it with them. Yeah. Whatever rights are there, they will be their tenants, whatever may be.
Yes.
Thereafter, they claim
is up to
occupancy
them.
right, whatever may be, that is another aspect of the
That
matter.
is of course not the subject matter of this.
So that will be another aspect of the matter which can go.
Right.
But I think this chapter needs to be closed with this, giving them that one.
Yes, yes. We have to talk about. The middle
Because-
way has to be.
Because this went into auction sale.
Some went in auction sale, my lord, now other persons have been settled. The difficulty, therefore, my lord, last occasion, my lord, we made a submission before your lordship that let us get hold of the record.
Now, in
Find
fact, it was not clear from the ADC's
This
document.
is even only one small report.
It was clear from the Mondal or whoever gave that report to the effect, one very important thing that this because ADC was saying something, the dark number 9 out there, dark number so and so 3, now it has been purchased by so and so and all these things. It was not so clear. And he further stated out there, as of now, nothing has been done.
Amen. Even here also, my lord,
But
we have to.
From the report of the Mandal or whatever, it may be, it was very clear one very important aspect that this has gone into auction sale.
Auction sale.
So at that point of time,
So therefore, lordship wanted to, my lord, see the report.
so you give him a copy
Yes, yes.
of this. We will
Definitely.
have it on here.
Granted.
It's a matter again on 19/3/2024. The top of the list. So certain documents have been placed by Mr. Arbo Pujari during the course of the hearing. It is the opinion of this court, a copy of the same be also furnished to Mr. P.T. Dutta, the learned counsel for the petitioner, so that he may also go through the same and make appropriate submissions on the next day. Further to that, this court have also taken note of various other documents which were placed on record, including the map, the original map which were being placed. So, another aspect of the matter which also requires to be taken into account as to whether it, the parties herein, the petitioners along with the respondent authority can settle the dispute in an amicable manner. It is submitted by the learned counsel for both the parties that an attempt shall be made in that regard. Taking into account the above list of matters,
At top of the list.
Lordship can permit the submission. If lordship is an intelligent side of, the parties may seek for a discussion in the office of the deputy commissioner. Some observation, my lord. That will give a handle in my lord order case. Some observation. That will give us a handle.
when
My lord. Yes. My lord.
you but explain the deputy commissioner, the problem they are.
No,
already-
definitely, we will be there. But can it be on my note, the 29th or my note, 1st of March?
It has been also submitted by the land council for the revenue department, the art officer. That for having an amicable solution, there is a requirement of the parties having sitting. Under such circumstances, he further submitted that on paper.
But 29th or otherwise, it might not put it, might not, the deputy commissioner will convene a meeting before the next.
Under
day.
such circumstances, it's for. You see, this is between both of you. Unless you say that you have instructions to that effect, then I can put it. Otherwise, it is between both of you. How can I direct the deputy commissioner?
No, DC may convene a meeting. DC may convene a, may, if DC may. convene-
Why should I say may or may not? It is not.
Definitely not minor, but some of the. If the
The
parties
observation
don't
is
do that,
if you keep the,
minor,
you
I
keep
will
the
purchase,
date
I
and
will-
tell me and you.
okay, I will.
According on 12th, it has been agreed to that on 12th at 12th, the petitioner shall appear before the deputy commissioner,
I'm up to that,
district commissioner
I'm up to that.
for a discussion.
On that, I'm so obliged.
So you give the date and time.
Yes.
For the records which were produced is to be again produced on the next day.
Will come as top of the. Will it come as top of the?
Huh?
Will it come as top of the?
Yes, I said, no, top of
Omelette.
Get once of documents, first it may be please to retain minor,
I am handing it over.
minor,
So this,
yes, yes,
give me a copy.
right now. Yes.
Okay.
I'm obliged.
It's better my not feel like has been paid to the.
Yes, you have got the money.
Yesterday that people.
Huh?
Yesterday they have people. Yesterday.
Money has been, so nothing remains. The record reveals that the petitioner herein have already received the amount of rupees 3 lakhs, which is the ex gratia payment. On account of the death of his father.
Yes.
Yes.
By the extremist.
Huh?
By the extremist. Extremist.
Death of father by the ex. Taking into account the above, in that regard, Ms. M. Burma, the learned counsel appearing on behalf of the respondent, have placed before this court a set of documents, instructions, kept on recorded. Taking into account the above, nothing further survived to be decided in the instant.
Problem.
May I please, Your Honor? My lord, matter relates to acquisition of land, my lord. Kindly see the order dated 2/2/2024.
Yes. You got the instructions
have-
this time from
I
the
have
deputy
received-
commissioner.
I have received mention that
in
award
Boko
for
police station.
money.
Boko police station.
Ahim Police House,
Lordship, is
You have got the money.
my lord,
You have received the money.
no money.
entire compensation was not. The 5 lakhs was prepared. And this is, we are expecting you to receive it from the required department. in a month. This is the impact. The award was passed on 16/6/2001,
Then
and the part of the money was paid to them.
when?
Paid to them pursuant to a honorable court order
16/6/2021,
21.
and the awarded amount is rupees 99 lakhs.
No,
No, 9
9
lakhs
lakhs
96,000.
and
The
and-
possession was handed over by the landowner on 7/8/2020 under Rule 5 and Section 4(1) of the a formal letter was received on demand from the requiring department and estimated and complete.
last two letters.
Have you paid the money?
My lord, the
No, my lord.
amount of 5 lakhs was paid. And the rest of the money.
How much you have paid?
5.
Where? Where is it? There's nothing, no
No,
document.
no,
of
not
here.
in this, the earlier it had come. Really, but
Where is this land?
My lord, Ahim.
Where? In the town?
Yes.
What is the price of the land?
I have exact price, no
Huh?
idea. Exact price, I have no idea. My lord, the land has taken possession in 1995. My lord. Page number 17 in my repeat.
This was the-
99.
this was the earlier instruction. 5 lakhs.
When was the land taken?
My lord, 1995. My lord. Page number 17 in my repetition. My lord.
What is the date? This is 2015,
My
page
lord,
number 17.
yes, my lord. Perhaps 13. My lord. Perhaps 20.
Perhaps, don't go by the perhaps business. It is your lookout. 2013. 28/5/2013. Okay, so then they took the land.
Yes.
And now the acquisition has happened in now, 2019.
Yes.
You have received how much? 5
My
lakh.
lord, as per in interim order of this court, my lord, I have received 5 lakh.
So the remaining amount would be how much?
4 lakhs. about. 4 lakhs.
Another 4 lakh something.
Yes.
4 lakh 9. So you are, if you are aggrieved with the amount, you go before the file a reference. If you have any other additional amount.
Yes, my lord, the price of this land is more than the value of the estimate by the department.
Mr. Counsel, should I say to you in estimate? Am I not telling you? that if any other amount if you are entitled to, you file a reference before the court, a collector to make a reference to the court. Because they have calculated the value at rupees 70 lakh, 70,000 per bigha. In a town in Ahim, I don't think 70 bigha it is 70,000. So under such circumstances, you require to pass, because now it is only now they have placed on record this. We will take it as on today. So within 6 weeks, you file an application for making a reference. And they will make the payment when?
Possibly within March.
No, and interest? What about the interest? You have only paid a part of it.
Part of it.
What about the amount? Other amount?
Other amount is, say about 4 lakh.
No. Only 4,99,000.
Interest.
What did you see? It was done in 2021. Where
21.
2021? And I got how much? And what is the interest thereupon? The interest has to be at as per section 68 or something or something. You have to pay another 9% and then 15%.
Apart from that, we could
And when did you give 5 lakhs to him?
5 lakh after that some minutes of some
In 2022.
20.
12/12/2022, you paid this 5 lakhs.
Right.
As if you were doing a grace. When the award was passed long time back.
21.
If you have already passed an award, does it require an order from this court to pay 5 lakhs?
And that he is entitled.
No, not only entitled. Who is the
He
hearing
gets-
officer?
Madam.
This is a very serious thing. I think take note of who is the hearing officer for which this has happened.
I don't know because we had got it from.
No, you file an affidavit. I will, you pay this amount. You file an affidavit. We now will take an action against that person concerned who had delayed. As if it is something he's taken. His land you have taken. What is this? Can you do it in this manner that whenever you feel like you take his land in 2030 and thereafter you don't do one thing, then he has to come and file a writ petition. Then in 2022, although an award has been passed in 2021, you, as if you are doing a praise, you have paid him a 5 lakh rupees. What about the earlier amount from 2013? Have you paid a single amount to him?
Yes.
Can the state authorities take it in this manner? Who is the revenue? None appears for the revenue. We'll take it up. I'm coming in private. I think their commissioner and secretary revenue need to file an affidavit in this. It's not the way. And the DC also, the deputy commissioner out here also has to identify the reason why this entire amount has not been paid in 2021. And any interest, because I'm keeping the mandate pending, any interest which will be now due has to be taken from the salaries for this office. This is a direction which is required. Present restitution is a case of excessive and unauthorized executive actions on the part of the respondent authority to deprive the petitioner of his constitutional rights under Article 300A of the Constitution. It appears from the record, which is duly admitted, that the petitioner hearing who is at present 65 years old, was the owner of a plot of land measuring 6 figures, 2 kathas, 17 lecture, covered by tag number 288 of the 292 of patta number 195 of village Hahim under Luki Moja of Boko Revenue Circle in the district of Kamrup Rural. It was alleged that in the year 1995, one police outpost, namely Hahim Police Outpost under Boko Police Station, was set up over 2 bighas, 1 katha, 13 lectures of land of the petitioner. Thereupon, the petitioner approached the respondent authority on various occasions for relief of the said land or to pay adequate compensation for utilizing her land for the outpost. The respondent authority gave scant regard, SCN, to the various requests so made, and it was only after almost 2 decades that the additional Deputy Commissioner Kamrup wrote a letter to the Superintendent of Police Kamrup Aminga stating inter alia that the petitioner's land was taken up for the purpose of setting up the Hahim Police Outpost and the said police outpost have been possessing the land permanently, but the petitioner have not received any compensation. A request therefore was made that the petitioner be paid the compensation in favor of the petitioner be paid the compensation for which an acquisition proposal be forwarded from the office of the Superintendent of Police Kamrup Aminga regarding the acquisition of the aforesaid land for Hahim Police Outpost. Two months later, on 28/5/2013, the Superintendent of Police Kamrup Aminga wrote a letter to the Additional Director General of Police A. Assam stating inter alia that in the land of the petitioner, the Hahim outpost, police outpost have been functioning since 1995. However, there was no formal allotment of the said land and no compensation have also been paid to the owner. It was therefore requested to accord approval to initiate the process for acquisition and taking over the possession of the aforesaid land for Hahim Police Outpost. The Deputy Inspector General of Police Administration having received the communication dated 28/5/2013, requested the Superintendent of Police Kamrup Amin Gao by the communication dated 5/7/2014 to submit a fresh proposal for taking action. In the meantime, the petitioner continued to submit representation after representation, however, to no avail. The record reveals that there was certain correspondence, but nothing concrete happened. It is under such circumstances that the petitioner was compelled to approach this court in the year 2017 by filing the instant writ petition. The record reveals that pursuant to the issuance of notice, the Superintendent of Police, Kamrup Rural, had filed an affidavit on 18/9/2017, admitting inter alia that the Hahim Police Outpost was established in the year 1995 and was situated over the land belonging to the petitioner. It has also been mentioned that various steps were taken for the purpose of making proposals for acquisition, but nothing was done. Thereupon, when the matter was listed on 17/10/2023 before this court, it was brought to the attention of this court that an amount of rupees 5 lakh was paid to the petitioner as an interim compensation. Under such circumstances, this court fixed the matter on 17/11/2023, directing the respondent to apprise this court as to whether any acquisition proceedings have been initiated in respect to the land of the petitioner, and if not, why. The record reveals that on 17/11/2023, an instruction was placed before this court which have been kept on record and marked with the letter X to the effect that certain papers have been received from where it appears that the LA proceedings was initiated on 21/11/2019 and the matter was pending with the Home and Political Department for release of the balance amount. This instruction is dated 10/11/2023. Under such circumstances, when the said communication was placed, this court directed the counsels representing the respondent authorities to apprise this court on the next day as to whether the remaining compensation amount have been disbursed to the concerned authorities, so that the same would be disbursed to the petitioner. The instruction thereupon the matter was listed on 8/12/2023, 22/1/2024. However, no no information, no instructions was placed before the spot. Because today, when the matter has been listed further, when the matter, this court further finds it relevant to take note of that on 22/2/2024, the instant petition was listed. It was submitted that some acquisition process was initiated, being LA case number 12/19, in connection with the acquisition of the said land for construction of the Hahim outpost, police outpost. However, the instructions were not clear as to whether any award was passed in the matter. Under such circumstances, this court fixed the matter today on 7/2/2024 with a direction to the respondent authority to apprise as to whether any award has been passed in connection in respect to the acquisition of the land of the petitioner, and if so, when it was passed. This court also directed to obtain instructions as to whether the possession has been taken away and when the possession was taken. Today, when the matter has been listed, Mr. B.T. Talukar, learned additional senior government advocate, have placed certain instructions dated 12/2/2024 issued by the additional district commissioner Kamrup Aminga. From the instructions so received, it reveals that an acquisition proceeding was initiated being land acquisition case number 12/2019. It further revealed that from the said document, that the initiation of the acquisition proceedings have been shown on 10/11/2020. And on the basis thereof, an award was passed on 16/6/2021 of an amount of rupees, thereby determining the petitioner's entitlement of an amount of rupees 9,96,928.92 paisa. This court has duly taken note of the award statement, which reveals that the value of the land was taken at rupees 70,000 per biga, which corresponds to rupees 7,000 per lesser. 7,000, no? 70,000 divided by 100, how much? Divided by 100, how much? 700. Which corresponds to rupees 700 per lesser. It is also seen that the compensation, the determination of the compensation has been done under the, I think on 2013 or right to fair compensation, or 2013. And the interest has been calculated in terms with section 30, bracket 3 of the said Act of 2013 with effect from 10/11/2020 to 16/6/2021. The record for the reveals from the said materials on record, it also reveals that on 7/8/2020, much prior to the initiation of the acquisition proceedings, the land has been shown to have been taken possession. However, strangely, there has not been there is no mention whatsoever about the interest in terms with section '80 of the Act of 2013, which stipulates interest at the rate of 9% for the first year from the date of taking over possession, and thereupon at the rate of 15% after the completion of the first year. This court had put a point of query upon Mr. B.J. Talukdar, the learned additional senior government advocate appearing on behalf of the respondent authority, as to why the remaining amount of rupees 4,96,928.92 have not yet been paid, in spite of the fact that the award was passed on 16/6/2021. The learned counsel, however, had no answer to the said query. The said materials on record, the said documents which have been placed, forming a part, is made a part of the record and marked with the letter Y. From the above facts enumerated, it would be seen that the petitioner have been deprived of its constitutional right to enjoy its property since 1995. Admittedly, there has been no compensation paid in that regard as regards the unlawful and illegal possession of the respondent authorities over the land of the petitioner since 1995 till the initiation of the acquisition proceedings on 10/11/2020. Thereupon, it is further astonishing to note that although the award was passed as far back as on 16/6/2021, no amount was paid to the petitioner, save and except an amount of rupees 5 lakhs, that too paid in view of the directions passed by this court
My lord, 16/11/2022.
On 16/11/2020. That too, the said amount was paid on in the month of February 2023. As could be seen from a perusal of the order dated 28/2/2023 in the instant proceeding. The above acts on the part of the respondent authority clearly therefore show that the petitioner's rights under Article 300A have been violated and if there was no direction passed by this court on 16/11/2020, even the said amount of rupees 5 lakhs would not have been paid. It also appears that the respondent authorities have assumed that they have right over the land of the petitioner, that too without authority of law. Under such circumstances, this court directs the respondent authorities, more particularly the respondent number 1, 2, 3, and 4 to take immediate steps for payment of the remaining consideration of the amount of rupees 4,99,000. 4,99,000. 4,928.92 to the petitioner, and the said amount should not and forthwith and not later than 10 days from the date of the instant order. The amount of rupees to the further to that, this court directs the said respondents to calculate as to what amount the petitioner would be entitled as requisition expenses, as compensation for the period from the year 1995 till 10/11/2020 on account of the unauthorized and illegal occupation of the petitioner's land. The said amount, upon being determined, be placed before this court on the next date. This court further directs the Commissioner and Secretary to the Government of Assam, Home Department, either by himself or through his delegating, make an inquiry. As to yeah, this court further directs the said respondent numbers 1 to 4 also to determine as to what amount of interest the petitioner herein would be entitled on the would be entitled in terms with section 80 of the Act of 2013 as on the next date, and submit a report in that regard. This court further on the next day shall, on the basis of the reports so submitted, take note of what consequential directions are to be passed in respect to the erring official which led to this non-payment, which led to the violation of the petitioner's rights, constitutional rights under Article 300A, and non-payment of the compensation amount, which led to an unnecessary burden upon the state exchequer. This is the matter on. Yes, let's take it on an unlucky day for you. 13th of the top
Most of it,
and shown as part of it.
most of it.
If this to Lordship,
Mm.
Lordship,
Oh, this one, LOC.
LOC.
Yes, why are you not paying that? Pay that.
my lord, all the relevant documents and files
How
are
much you are entitled to, Mr.?
1,61,000.
1,61,200
Then
in the year
Paying that.
91.
Lordship, till that no record is in the office, Lordship, as on today, the Lord, all the
But
records
can
in
you
the
keep it like this?
Lordship.
You are entitled to, you will be liable to pay interest. And the interest will be from that official. I don't mind. You see, the public revenue, public exchequer needs to be protected. It cannot be at the cost of the public official. The public officials has to bear this interest. Then only the public officials will.
You've already written a letter to the CPA.
You right, whoever it is, you held up that amount categorically on the basis that there is a LOC case against him. He had been acquitted in the LOC case. He had nothing out there. So under such a way, you were supposed to return the amount. Why haven't you returned it? This time I could see in all these newspapers, Assam Pratidin, as Tribune and all, you have
Okay.
given 8 or 9 pages of what do you call the budget printed out. So from there, I could see a lot of money going to the animal husbandry. From there, paid it. See.
Lordship directed to
I'm having it on port. Pay the money in the meantime. Whatever inquiry you have to do. You need to pay them. Can't go like that. Thereafter, we will consider on the question of interest. If you don't pay. Therefore, the instant writ petition has been filed by the petitioner, being agreed by the inaction on the part of the respondent authority in making payment of an amount of rupees 1,61,200 to the petitioner, along with adequate interest from the date of submission of the bill till the date of making payment, as well as adequate compensation. The record revealed that the said amount of the petitioner was withheld by the respondent authority on account of the petitioner being implicated in special case number 55/2004 new oblique 50 special case number 22C/1997 oath. It is also seen from the record that it is also seen from the judgment delivered in the said criminal proceeding that dated 10/11/2016 that the petitioner have been acquitted, isn't it? Mr.
Yes.
Petitioner has been acquitted.
Yes,
Where?
judgment is there.
Huh?
Judgment is there.
Where?
Eh.
What is the name of the petitioner?
Madan Bora,
You-
paragraph,
Hold on, 21.
penultimate,
Accused number 24.
Yeah.
Where is accused number?
page 44. Yeah.
Have been acquitted. As could be seen, more particularly as could be seen from paragraph number 60 of the said judgment. It is under such circumstances, the petitioner have requested the respondent authorities to release the amount of rupees 1,61,200. However, the said amount having not been paid in spite of the petitioner approaching the respondent authorities time and again, the instant petition has been filed. The record reveals that notice was issued as far back as on 1/12/2020, one turn on when
22/2018 for her.
on 28/2/2018. However, till date, the respondents have not filed any affidavit in their position. So this court had granted the respondent authority time on 8/1/2024, 22/1/2024, and 7/2/2024. However, it has been the consistent stand of the respondent that they are not in a position, they have not been able to locate the file. Considering the above, this court picked up the matter on 11th of March 2024. Full stop. This court observes that the respondent authorities shall take appropriate steps for carrying out the verification as to whether the petitioner is entitled to the amount so claimed. Within this period, and if it is found that the petitioner is entitled to the said amount, to pay the said amount to the petitioner. Full stop. On the next date, the learned counsel appearing on behalf of the petitioner, a respondent, shall apprise as regards the status of the inquiry and as to whether the payment has been duly made.
All right.
Oh, that matter. It is not finishing. Why?
My lord, may I
Last
pray?
occasion, my lord, we have challenged the notification and the reports came from the government that yes, it was notified. Thereafter, my lord, he took some time, my lord, from this honorable court to go through those reports of the government. And my lord, that is reflected in that order dated 18/12, my lord.
My lord, may I pray one thing, my lord? My lord, I had challenged even a subsequent notification by another writ petition. In that writ petition, my lord, the 3/2/2022, the order was passed to take with the both the matter together, my lord.
Huh?
That notification I challenged, my lord. The subsequent, because my lord, the crux of the case is my lord, annexure 10 of the present, my lord, writ petition, where they have mentioned the notification, the master plan that was published in 2019-77. And on the basis of that, my lord, the notification was for demolition was public issued. And subsequently, they failed to brought this notification. They now subsequently brought this notification 2010. So on that, I challenge, my lord. Because the notification they issued,
There's a separate challenge.
my lord.
There is a separate challenge
Yes, my lord.
by filing another
Yes,
requisition.
I have filed, my lord, and there is an order 3/2/2022 that to put the matter to be clubbed. My lord.
So we do one thing, it has not been clubbed. We dismiss this, you avail your
No,
immediate
my lord,
other one.
lordship, my lord, dismiss it. But before that, I want to show one
It has
thing, my lord.
become inducted.
No, my lord, this is not infrastructure, my lord. My lord,
As of now, nothing remains. You are challenging it that.
My lord, then, my lord, on the basis of that,
Making it long out.
no, my lord, kindly see my annexer 10 of this petition, my lord.
There's no
Annexer, because everything
Here
is there.
you have not constructed without permission.
My lord, without pleadings, my lord, they cannot say anything, my lord, first of all. And in the second petition,
Without pleading, you cannot say anything.
my lord, I have said, my lord.
You have not challenged.
Lord, I have challenged, my lord.
As of now, there is no challenge.
No, my lord, I have, as of date, I have challenged, my lord. Kindly see, my
How do I
lord.
know? How will I take petition?
My lord, kindly see, my lord, the annexer 10 of my petition, my lord. Kindly see, my lord. Have a look.
Page?
Page, my lord.
Page 31.
Yes, my lord.
Typical.
In that notification, they have specifically mentioned, my lord, line 3, it is hereby inform you that you have illegally made a construction within the said Tezpur master plan, which was brought by Assam Gov notification such and such dated 25/10/77. So initially, from the very beginning, I, my lord, pleaded that there was no such notification, and court directed to brought this notification before the court.
Then,
But they brought the notification 2010. 10 notification, my lord.
so they should have, but they have wrongly done it.
No, this is not being wrongly done, my lord. This is they are not correct.
Your submission is this particular document or the impugned letter. It states about the notification of 2017. Now they are being on record at 2010. Isn't that your case?
Yes, my lord.
Yes.
Because my lord, I have responded this
You
notification.
do one thing. Withdraw this. Yes, for 2010. Withdraw this and then we could see the.
Because my lord, I have given the opportunity to reply on this
Why
notification.
should we go into all these unnecessary?
Definitely not, my lord, because ultimately it is the, my lord, question what he has, my lord, projected before the court was at that point of time was that this place where the building was constructed was not within the master area, my lord. And that is why, my lord, the development authority was, my lord, inefficient in passing the notice of demolition. And he said that because he has obtained some, my lord, permission from the, my lord, that Gaon Panchayat, and that is why that is to be considered to be a valid, my lord, permission. And thereafter, my lord, after all this time, my lord, it too reflected that, my lord, that area, despite because I had already been saying, my lord, with notifications and all, that it falls within the master plan zone of Tezpur, my lord, and it is the development authority is empowered, my lord. And now he challenged that was brought by the government, my lord. And today again he comes up with these things, my lord. Now, my lord, just putting a authority, ultimately the law remains, my lord. When the power remains, my lord, and if suppose, my lord, the power or some is wrongly quoted, my
one
lord.
thing, my lord. If you issue a so-called private,
Yes, my lord.
where is that?
And SOCOS was issued on 2018.
Wait,
And my all construction and my lord, the date were carrying on 2016. See,
That
That is
date, my
completed.
lord, 31
It is
itself is a
retrospective
so-called-
notice.
where is your so-called?
That's
Suppose
31,
yes, my lord.
page 31, my lord.
Page
Huh?
31 of my.
Page 31 is the so-called.
Yes, my
Yes,
lord.
ma'am.
He's coming against the so-called.
Yes, my
Yes.
lord.
You do a fresh,
Because I have
if this
responded.
is a so-called, you do a fresh so-called, material.
But thereafter, we have taken a kind of decision, my lord, to demolish because of the fact that he did not reply. And he, in the so-called reply, he stated that there was no permission and he sought for permission by that reply, my lord. And the government
Page is reply.
at the next page, my lord.
Connection I have
Page
constructed
32.
that. Yes, you want forgiveness. You want on one hand forgiveness and now you are fighting against.
No, my lord, this notification at that time that was not published, whatever is by
Sir,
submission.
did you in your reply say that he was not entitled to?
No, that
They have no
that
business of-
reply was, my lord, that is not a detailed, my lord, reply. That is a person himself give the reply. That is why,
When
my
did you
in
give
that
a
way.
detailed reply?
But the crux
No,
of the
no,
case,
when did you give a detailed reply?
my lord,
But it-
detailed reply, my lord, this is a reply. Then immediately they issued a demolition notice, my lord.
And-
Next, Annexure 12, my lord, this next phase, my lord.
Sector
40,
12,
40, my lord.
sector 12, page.
Yes, my lord. Page, Annexure page 41.
Nowadays, when did you construct
16. 16, my lord.
2014 days of six? Yeah,
Yes, that is for Guwahati.
no,
It is
no,
our Guwahati.
And therefore, no, but
it is not
other than
for
Guwahati,
Guwahati.
other than Guwahati also.
That is.
Yes.
So there, city final takes up 30,
Yes,
so there also is a.
yes, my lord.
That-
No, my lord, the
So that is why, my
that-
lord,
that
this
area was not-
petition has become infrastructure.
My lord, that area, my lord, the Mahabodhi, my lord, this particular area, that not come under the, my lord, Tezpur Municipal Corporation, municipal court, my lord.
But
That
you
was-
have you approached the municipal court of that?
No, I approached the Gaon Panchayat, my lord. Gaon Panchayat has given the permission, my lord. And then to that effect, Gaon
Have
Panchayat
you
has,
taken any stand before the municipal authority that
no,
here,
because, my lord,
here this does not.
everything, my lord, I obtained the necessary permission for the Gaon Panchayat, and after
You
getting
are
all the
every
permission,
day you are
industry
coming up and
department-
bringing,
my lord, industry
trying
department,
to make the case better.
my lord, my lord, industry department on the basis of these all documents fulfill. Then they have issued the, my lord, trade license to me and as a, my lord, industry to start the industry, my lord. So as the basis of that industry, my lord, license, I have conducted the industry operation, my lord. This is the fact. Yeah. No, whatever may be, my lord.
No.
But municipal, I did,
That is not a part of your case.
I did not, my lord, because it is,
But
whenever, my lord, the Tezpur Development Authority is come, so I have responded to Development Authority, my lord.
have you
Municipal,
mentioned
it
it
did not
to
come, my lord.
the development authority? Yeah, that's what you have no business out there.
No, my lord, my lord, kindly see, the construction, my lord, they demolished, but the proposed notice, they say to stop the construction, my lord. To stop the construction, by this time, 2 years back, I have completed all the construction and industry and all operation was going on. So on that, I specifically replied that this is done in 2016 and retrospective the notice can be done by the demolition. And that too, 77 they have specifically stated. And without pleading, my lord, how they can, my lord, say that this should be demolished by the only production of the 2010 notification. This is not the case of the respondent side. They never say that this was a 2010
Hey,
notification.
you have been asked to stop. To stop. It also to support it.
Yes, yes, that is true, man.
That-
That is true. But whatever may be, but the 77 notification, how they came now with the 10th notification, my lord, this is the fact, my lord.
Yes,
The entire
the
notice is
notification that
defective.
is there to-
And if the entire notice is defective, my lord, whether on the basis of this thing, my lord, they can go with the, my lord, further action. This, my lord, the Supreme Court also only all the cases saying,
Then better
Then
go
it
to
is-
Supreme Court. Let
my
go
lord,
to it, then immediately
they
go to
cannot
the
go
decision bench,
beyond
then
it.
to Supreme Court.
please, my lord. So my prayer is this, my lord, this is not the only structure there. The lots of hundreds of structure there.
Hundreds of structures
Many
in the
office
different- go and buy a-
adjacent of Lordship kindly bear with me, adjacent to my land, I have specifically said in 2013, one is a government market has been established. Gaon
What is your
Panchayat.
subject matter of challenge of that?
My lord, one problem will arise now after that. If Lordship, my lord, they pass the, all right, my lord, Lordship, whatever will pass. And if you go by always emphasizing on my part that I should demolish my house, then they will fall in a great trouble in future. Because I am telling you one thing, my lord, if this is, my lord, by law it is barred, then somebody will come with a PIL, then entire, my lord, the structure, whatever is there, that should be demolished.
Very bad, because- So
And
how-
that
how
is
am I
that
confident?
will be happen, my lord.
how are they? They will be happy.
No, well, why they are particularly choosing my construction? Well,
Because
this
you
is
are
where
fighting. So,
he can
others have
choose
already
manner.
been demolished.
Then I have to go for demolishing all these structure. Well, why they are choosing
That
to
I'm not- that others,
But-
you see,
But my submission is
the
when I,
Monza, if I see it something with the different, with everything.
But my humble submission is, Palor, on the basis of that notification, when I take
As
that
of
away.
now, a simple matter has been made unnecessarily
Not complicated, my lord. From the
complicated.
very beginning.
First of all, you were asked that how have you constructed without the permission? You never said that you have, the permission was not required. You asked for forgiveness for construction without permission. Under such circumstances, they come up and say that look here, this is a land which is Bautoli and without the permission you could not have done so. Matter there end.
No.
Now every time you are coming up with new things.
No, I am not on new things, my lord. The court-
Absolutely.
No,
Where-
my lord.
no,
No, my lord.
so
Court is from the
no,
very beginning.
no, Mr. Monto, where is your, show me one document out here in your petition that you have stated anything about that this land does not fall within so and so.
Yes, sir. From the
Where?
very beginning, my lord.
Where?
I have my para, my lord.
No para business. Document.
No, no.
Document.
My lord, from the
document.
section
No para-
10 also I said, my lord.
Absolutely.
comply to
Don't
section
bring
10.
in the questions of law
Section-
out here.
My lord,
here.
section
You-
10, my lord, I have
you
from the
address
very
them.
beginning taking the
Whether
plea.
it falls or
This-
not. Is this the court to decide? Yes, this dark number falls in this number and so, and this is doesn't fall.
I am not on it,
And
my lord.
from that
My lord,
report
from the
out
very
there,
beginning-
from there, it is apparent that in 2010 it is so.
No, from the very beginning, my lord, I am telling one thing, my lord, I am submitting one thing, that they have not complied the section 10. So far the 77 notification is there. So section 77 notification is not for the as part of compliance of the section 10 of the Town and Country Planning Act. Then notification will not give you an effect, my lord. My submission is this. Now they claim the notification of 2010. So comply with section 10. Town and Country Planning Act. They are not able to show that this notification was published 77 as per the section 10 of the Town and Country Planning Act. This was my case from the very beginning.
Where?
My lord.
You said that there was no notification at all. Then only this court
Yes, my lord.
directed them. Now
Yes, my
you are
lord.
saying from your beginning, show
My
me
lord,
that.
to the,
No, Mr. Mohanto.
to
If
the-
you are making that submission, this is the subject matter of.
my lord, I have submitted in my plain.
No,
my lord.
you show me in your writ petition that there was no notification in terms of section
Yes,
10,
my lord. Yes, my lord.
that it was not published in terms of section 10.
Yes, my
Show
lord.
me,
Yes, my lord.
show me.
There is from the very beginning, my lord.
Where? Your basic case is at para number 10, wherein you say that as per section 13(4) of the Act,
Yes.
the authority is not authorized to refuse in granting permission except on the ground of contravention of the proposal contained in the plan or regulation. But till date, no notification under section 10 has been published. So it is not your case that no notification in terms with section 10 has been done.
What is this section 10?
No, kindly, there is a much difference. There is a much different topic for which I think this needs to be further explained by the division bench. Let me
No,
dismiss
my
it
lord.
right.
My lord, lordship, my lord, they kindly consider one thing, my lord.
I
From
don't
the
consider
from the very beginning, para
consideration
10,
is gone.
my lord,
I've
this,
considered many things. I've asked.
my lord, this
considered
77 notification
this is a
was
big
not
case
as
now
per
for
the
court.
section 10 of the Town and Country Planning Act. This
Not
is my
required.
beginning, from the very beginning, writ petition, I stand on that, my lord.
This is a final notification. Annexure 1 categorically shows that in exercise of the powers under so and so, read with so and so, please to publish the following notice regarding the publication of the revised master plan. Notice for publication. This has been done. It's been done.
My lord, they are not able to bring the 77 notification. They comply this provision, section 10, they have published.
77? What
Yes, my lord.
77 is required?
77, because. the
No,
notification is
first, no,
77.
Mr. Moto.
My lord.
Show me where is your pleadings that the 77 notification? Tell me,
My lord,
where is the pleading as regards the 77 notification? There's not a pleading out there. come up with.
My lord,
also.
I have specifically in para 10, my lord, I have specifically mentioned, my lord.
You have not mentioned
It is-
about the 77 notification.
My lord, the crux of the case is
Don't
77
come up with
notification,
your
my lord.
crux. The crux is to be understood by a division bench, not by this court.
My lord, 77 notification, my lord,
Where?
whenever I have
Where
stated
have you
these things,
mentioned
my
in
lord.
paragraph number 10
Let me see,
about
my lord.
77? Not a single word of 77. Now you are coming up.
My
with
lord,
all-
my lord, kindly see, my lord, one thing, my lord.
Why? Why?
Lordship kindly in the entire para, my lord.
Hmm.
That the petitioner beg to state that as per the section 13(4) of the act, the authority is not authorized to refuse the granting the permission except the ground of the contravention of the provision of contained in plan of the regulation, but till that the notification under section 10 has not been published, earmarking the entire land, tag number 145 by PP number 44 for a particular purpose. Hence, the absence of the any provision for which the said land has been earmarked, refuse the permission merely on the ground of land of petitioner is Bautoli without considering the absence of any agricultural activity since 1966 in violation of section 13(4) of the act. Hence, the demolition of the notice dated 19/3/2018 issued by the respondent number 3 receiving on 23/3/2018 is absolutely illegal and liable to be set aside in court.
Where?
So this notification
Where
is
is
my lord, saying these things,
77?
my lord.
Where is 77? There is not a single whisper in your petition about 77.
My lord, the notification I have mentioned, my lord, 13th notification. This notification itself will run.
Where is your notification on
Notification
13?
13/3/2018.
Where?
This is Annex 13. This is Annex 13, my lord. The entire content will come.
Where?
Annex
Page-
13 at page 31, my lord.
Annex 10 is what?
This is the same thing, whatever I mentioned, my lord. 13/3/2000.
This is not
Subsequent-
a notification.
The subsequent notification, my lord, 19/3 demolition notice. My
No,
lord.
where have you mentioned about 13.4 notification? Where is the notification under 13.4? There is no notification
No,
under
my lord.
13.4.
This is 19/3, my lord, subsequent notification, my lord.
Where?
This is Annex 12 at page 40.
Annex 12 is an order being passed by them. It is not a notification.
But on the basis of that notification, they have issued the demolition notification, my lord.
Why?
Because they
See,
are not satisfied.
No,
with
the
reply.
simple thing is, no, Mr. The simple thing is they are doing it in terms with the Assam Municipal Act. Assam Municipal Act, no.
No.
Yes.
No.
You see, I am saying it is yes, anything you are defer,
Nowhere
there's
it
a
is
division
reflected,
bench.
my lord.
Okay, let me decide.
Nowhere it is reflected, my lord. My prayer is, my lord, this entire, my lord, exercise done by the, my lord, the development authority is, my lord, is nullish, my lord.
G. Chaudhary appears on behalf of the respondent number. Respondent number
Phone number, my lord.
3.
Three.
3.
No.
No.
The Tezpur Development Authority. 3. I take this.
You are appearing for all others?
My lord, before that, my lord, also, I want to draw
No,
one thing, my
enough,
lord.
enough. 1, 2,
My additional affidavit, my lord.
4. I am not looking into 5, 6.
On production of their, kindly,
Who
my lord,
appears for
see,
the private respondents? Why are the private respondents made parties?
because, my lord, very, very interesting, my lord.
Some part of
My lord, they,
cell within his land.
earlier, my lord, he implemented, prepared for the implement of the private parties, my lord. He representing those private parties earlier. Now, my lord, suddenly he's leave up those parties and jump to the, my lord, the development authority to defend.
He appears for private parties.
Private party, he himself, my lord.
I think
I had filed an implementation, but later on, I thought I was.
no. How can you then have the same interest with the Tezpur
Yes, my lord.
Yes, because the
They
their land were, my lord, encroached by him. That is. No, they did not
He
have,
is making an allegation against you,
my lord.
Tezpur Municipal Board,
Tezpur Development Authority.
Development Board, and you are the Tezpur Development Board as well as this beneficiary of
Yes.
their action.
Not beneficiary of the act. The beneficiary.
Why have you made 10 to 7 to 9?
they claim that my demolition.
I
is
opened
done.
the house.
Land were, my lord, encroached by him.
The 339.
Yes.
339.
They claiming their land there belongs to them. which I, my lord, purchased by way of a degree from the court.
So you have a conflicting interest.
Yes, my lord.
These persons have a conflicting interest with the petition.
Yes.
And they categorically say that the petitioner was never given the permission to construct any building on that land.
Yes.
And you are representing their interest. And at the same time, how are you representing the Tezpur Development Authority? though?
For the reason that, my lord, some amount of their lands, my lord, were taken over by him, my lord. That is what we wanted to bring it to the notice of the court. But for the rest of the other lands, my lord, it was, my lord, government land which he was occupying, my lord, and for that the development authority thought, my lord, is the without harm.
Government land, I have not occupied government land, my lord. What is
His
submitting?
construction is not on the government land.
No, my lord.
His construction is on a Bautoli land wherein he had constructed without the permission of the Tezpur
Yes,
Development. That's all.
So, my lord, for the development authority, it was
No,
limited only to
no,
the-
but how can you represent both? On one hand, those persons are against him.
Right.
And you being a authority under Article 12,
Right.
you are to be neutral.
Yes.
Then if the same council is appearing on behalf of that, where is the neutrality?
my lord, this petition was filed only for the purpose
No,
of,
no,
my
no,
lord,
no. There
going to
cannot
the
be
court,
this
my lord.
decision, that position. How can your presence be can considered to be neutral?
But later on, I had abandoned it, my lord.
You
I had
can't
not
abandon
agreed
it.
to
You
surrender.
had
lord.
at one point of time you had
My lord.
appeared. And within then it can be construed that you are in a position, you have still, you see, obviously I would not say that you have still continue to have a non-neutral stand, but on the face of it, wouldn't it show that you don't have it?
But then the
It is
extent of
also
the
to be
interest,
seen.
the extent of the interest was that, my lord, we had even encroached upon my land and constructed.
Understood. But why have you brought those people out there and appeared on their behalf? That means you are against the petitioner. And the
I
same
am-
council is again appearing for the Tezpur Development Board. Today, Mr. Mohanta is safe because of that, giving Tezpur Municipal Board to engage.
My lord,
Otherwise, this case is for a fit case for this. Next time we talk. Anyway, this matter is not going away. Everywhere it goes, it comes back to me only.
can it get me fixed, my lord?
It would not be proper for you now to say a date be fixed. It would be better that Tezpur Development Authority be asked to ask somebody to represent. Mr. G. Chaudhary, the learned counsel appearing on behalf of the Tezpur Development Authority, fairly submit that for him to represent in view of earlier representing the private respondent, there might be a conflict of interest for which he fairly submits that he would like to advise the Tezpur Development Authority to engage some other company. Taking into account, he submits that, therefore he submits that 2 week time may be granted him so that he can apprise the Tezpur Development Authority to take needful action. Or this matter 19th of March 2000. Along with
My lord, WPC
why this point dismissed
521, my lord, 2020.
521/2020.
I'm duplicate. Mass submit.
Your lordship, but the instruction received, application under
Hmm?
preparation, my lord. Affidavit in under preparation. But 2 weeks time may given.
What preparation? What affidavit?
My lord,
This type of matters, why? This matter has come up. Why? What do you want?
Lordship, non-payment of contract for bill.
What is your instruction?
my lord, instruction is not with me,
With whom?
with P Nayak, my lord, with P Nayak.
So,
So, he informed me that he will file within 1 week, my lord, 2 weeks time. will give it.
no, you verify if he's entitled, pay. Verify and pay. Verify, pay. Dispose.
Dispose of it.
You can pay. If he is entitled, pay.
My lord, one,
Verify within 1 month and thereupon pay as per.
my lord, 1 week time may give it.
No. Sorry.
Next week, my lord,
2020.
my lord, last month may given. Actually, instruction is like,
700 Lordship, 7 council.
kindly allow me 1 week, my lord.
Okay. Subject to cost.
No,
He has to pay. Pay his daily fee. Because we determined it to be 20,000 per day.
no,
Pay.
no,
Dispose. 6
Public.
months. First course, 1 in 2 months. It to be verified and thereupon paid as per contract.
Public.
If he is entitled, pay. Otherwise, you don't pay. The backdrop of the above static fact it for the work, the stadium after it appeared to the educate the tribe to take the track out of the subject it not it state to be that to be difficult or entered it having at the at that it that it the the fact that it would have been taken for the that it but gave exact it is public of that the way of it but it would the backdrop of the above report refers to that it kind of the to the doctor who that the factual of it are better which the fact better sequence the it was duly observed that the court that it called this which the fact that which evidence of the day the third point was interpreted of the part that this court, however, if the opinion that the dismissal of the restriction of the draft of the case is not to approach the appropriate Supreme Court for the restriction of the case, if it otherwise permits of the law. This court of the opinion that appears to give the period that the case before this court are required to be excluded by the deputy. As much as the petitioner was still advised that it otherwise case then before the court. It is, however, clarified that this court has not enlarged the permissible period of the petition. This court has directed that the period of detention of the the date of for the purpose of convenience, this court, that means the case could not get the deputy for the with the above Mr. Pathak, you see that matter, Mr. Das was there, na? That judgment I've given it, that forest matter. I know it was context, but the records are with, so those are the records. that I've asked them to, I've notified that clearly I held out there that the fact that the disqualification has not been up ground for second as per it that it but the question that right whether to but whether then I have taken into account that then the entire system of the submission was made, recorded, already 26 nights. 26 nights. No. Thereby, there was the static. Have made the entire auction proceeding needed, taking into account that those documents did not work at that point of time. There was no recorded physical copies that at that physical copies given on 29 which means the last date of submission, the sanctity involved with the last date of the submission has been. So under such circumstances, question that it needs to be tendered. Another aspect is the tender was for a period from 2001 to 2021 to 2027. We are in the year 2000. There, the persons who have voted the were granting any benefit or granting them from the date of the agreement now would be giving them the benefit for 3 years, which was never completed by them. Initial, but don't go for the but that consider picture different, as I said. That it has the meaning of it has been good. Because physical verification later on, which you can insert also any document. In fact, I won't say about the case in 1466, but in the other case, 178, where is the ESP, CIT, and that document, there is not a single mention in the bid letter as well as also in the letter that they are submitting the application. But the undertaking was there. But your logic was there separate taxes or but in that case will depend because if it goes, we'll also there also I held it because you see clause 13, there is one segment of rejection of the bid. When can be the rejection of the bid contrary to the bidding document. Now the bidding document permits them to submit the list. Now we are to bidding on the basis of that order of bid. That is bidding document can take me to that undertaking whether it was there originally or not, that is not the that is contrary to concept condition. Absolutely. It has to be that if you see I recorded earlier when Empron came up with that letter for retender, they thought I now once they have completed that they are going to 8 But it became open and thereby made the process useless. If they realize it, and they say that there was no manipulation of the document. And by putting the state in the court of right in the meantime the court and thereupon they concede. There's no way of. But if you look into the physical documents now, they have everything. It makes it again even if we consider your tender was properly done and all, you had a very good right, but that right has
Delivery.
delivered.
Deliver online.
No, it will come up. I don't think it take the deliver. It the date. What the that. Yeah, yeah.
You were directed me to file an affidavit. And they both are.
My
The doctor directed to file an affidavit, my lord. Lord, I have filed it, but the doctor directed me to file it on 4/8/2. File posting my date, I have stopped. There's some mistake.
filed
my lord.
it.
They have filed it on 13.
Wait it.
I have not. I'll punish him. I have it.
my lord, your lordship has directed me to make it a chart, so I have prepared my lord for your lordship. Because
I have shown it more than 11 or 12 cases is appearing. 11 or 12 cases is appearing.
no, not me, but SP Roy and others also, my lord. So I have tried to give a pictures about this market.
Now, Mr.
Allotment is given to us. We have filed registration fees as well as my lord security fees. After that, somebody occupied, that was cleared. And rent was also paid, my lord. Your lordship has asked me last occasion, so I have collected some rent receipt, my lord. So now they should be acted upon because the person is a muscle power, we cannot enter the space notified. So that much. In our prayer, there is two prayer, my lord. You declare that we are allotted and to evict the outsiders. They have evicted, my lord. The list is also given. Now we cannot.
Sharing the but other secret behind the
Yes. Yeah.
Now,
Second part is done, that eviction is that this is kept
Done.
vacant. But we cannot enter because this pendency of the case. Secondly, my lord, the muscle power is not with us, my lord. We cannot tackle with them.
who has?
Who are the occupier? Who are the occupier, my lord?
Who is the occupier?
Because this now they came that
He is
they,
the occupier.
yes, they now came here.
He has
implement
the muscles.
that so they have some order in their favor, says that they are in western side, they are doing business, so there should be a vending zone and settle them. That is in their favor. Now they
It's
came
okay, but the question is, Mr. Bora, isn't it for the BMC to take it up and have your vending zone? You, if I remember that earlier matter where I passed the judgment where you were there and Mr. Anupam Sharma was there. Remember that matter?
yes, madam, that is the inside the market.
No, whatever you mean. In that, there is an affidavit being filed by them, by the GMC, stating in the area that they have a town committee and that committee has allotted various vending. You have the committee. Yes.
There is a committee, but in that particular case, these assessed persons were given a vending zone in the ninth floor of the GMC.
I'm not on that. That I know. That those persons who were there in this particular SS road has been given out there in the Medline.
Yes,
That I'm
there
not
is a
on that. But there was a
Count-
affidavit wherein it has been mentioned that you have formed out in terms of the vending act
vending.
a particular committee, and every area has a particular committee who is to decide. This is as per the street vendors. Now, this is the case of coming within the street vendor. Now, why are you not taking a decision on the basis thereof?
Now what has happened? Now, what the earlier survey was done,
7,200 odd persons were there. Now, another survey is after 5 years, you have to make a second survey, subsequent survey. Subsequent survey is also complete. Now, the ventilation committee is taking up all the things and they are trying to fix out a place where it can the ventilation committee take care. So, declaring ventilation zone is not an easy task because we have to consult the police. Whenever we're going to declare a particular thing, we have to get the clearance of the police, traffic and everything.
True.
That-
But
that is taking
whenever,
some time.
but are you not empowered by the 2014 Act
Yes,
to do so?
we have to do it.
Then
have
why
to
you are
do
not doing? You already have that committee.
Yes,
Then why you are not doing it?
Look,
All the problems with this type of litigation every time coming out there, it's all because of your inefficiency of the vending zone.
vending,
It's
vending.
problem. If you fix it out, because if you are the delay on your part is again creating a lot of hurdles or lot of hurdles on to you.
That's because they are underpaid.
Because if you now regularize, it can say that okay, these ABCD are being given a vending certificate. And okay, they will be vending from 10 to 8, 10 to 6, and then the other will be doing it from 6 to 9, whatever may be. You can very well do that. That is permissible under the 2014 Act. Why you are not doing that?
we are completely taking up this issue proactively and they will likely to come up with a policy like that from this basis up to before the office starts till 9 p.m. or 9:30. This vending will be done. After that, no vending.
No,
will be.
not
That's
only that. If you have
other-
too many people also, you can
Divide.
make it slot-wise.
Slot.
That is also a power being given.
Slot.
And thereby they also have a right. You also recognize, you also get your money, but you are not doing it. What to do?
My lord, when PIL is pending, my lord, in that particular PIL, my lord, affidavit will file the process is on. If you
Understood, the PIL is done, but this is the main issue.
Same-
Why
same-
this is
same
all these problems are arising out there. Or you don't want to make Mr. Borua without because or you don't want to harm Mr. Borua in without a litigation or something. Huh?
vending zone is a tough issue.
Then Mr. Borua's
Because the
litigations
case-
are being resolved.
I was a category 2 minor inner railing, but we are disturbed because of this pending to not pay.
And people
we already-
fully of Mr. MJ.
My lord, same issue, my lord. We have withdrawn 4 cases last 10 days back, my lord, your lord. Because allotment is given. That is why no impact has become into.
Now here allotment not given.
Allotment is given, my lord.
Allotment
We
is
cannot
given.
sit there, my lord. That is why I approach your lordship.
Allotment is given during pendency, they were not there.
No, you are already allotments. Why do you need a declaration now?
My lord, because they say that we also notified area where vending zone is created. That should be cleared, my lord, from my learned friend will help. I mean, clear, my
They,
lord, what
they
is
were
the issue.
allotted in the inner line, inside the railing.
Inside the railing, my lord. We
But
can-
while pandemic, they were not doing business. And the pandemic was ceased. Some other person has entered into. Then eviction took place. We have evicted. them. And
Then
they,
what happened?
then they are there now.
You're there.
My lord, problem is that, my lord, dependency of the case and my lord,
Okay,
we cannot
dispose it of.
overpower them, my lord. This is the
No,
task.
you withdraw. I dismiss it or whatever may be.
My lord,
You withdraw as you are now being given the allotment. So nothing remains.
our favor, my lord.
So
So
as
my-
you are granted the allotment, if any disturbance is there, now you are also sitting out there. What do you mean?
we are not sitting, my lord. That is the problem.
He says that you are sitting.
They are sitting. Now they have to say some area has been covered because of pendency of this and not allowing all the purposes. Because of this pendency. It says
Southern side is keep vacant, my lord. Since we approach this, so your lordship may direct that if assistance is required from police or GMC will take the care of it. We will see
GMC
tomorrow.
doesn't know.
Because
The
that
GMC
list
assistance
is with them.
required.
List is with them.
we have done it. We have
They
evicted it.
have the police assistance. Why should I give you the
My lord, that is why I
They have
approach
their
this.
own enforcement. Yeah, that was
We-
imposed.
That is why we approach the court of justice because we cannot.
No, they have already evicted
They
them.
we have allowed evicted.
So tomorrow is
Now, where is the space allotted to petitioner number 3 to 6?
TRP road, my lord. That is the
No, TRP road is very big.
no inside railing of the along the.
Now,
TRP.
are you allotted a specific space?
Yes, yes. L pattern. It is along TRP.
L pattern. L pattern is too big a place.
Yeah.
Are you being allotted a specific place? Yes, look
Yes.
here. You will
inner
be there
railing,
next to the corner of that Almira.
yes, my lord. Our side is, my lord, northern side of the GMC market, inner railing, northern side.
So you are there.
We
I-
are previously there. There is tussle is going on. That is why we approached this honorable court. Now, my lord, our allotment is there. Everything is there. Some rent receipt is also there, but we cannot carry out business because day-to-day tussle. That is why we approach.
So why are you not approaching the police?
Police said there is lot of cases pending. Somebody, they are western side, my lord. Their place of business was western side outside the.
You
my
are
lord.
Western side.
No, my,
My lord,
by affidavit, my lord, your lordship will kindly come.
my lord,
First,
No,
page number 36.
there-
Page number
there-
36 of the writ petition.
Page
Allotment letter,
number
36.
36.
36. of the
Yeah.
writ petition.
Who is it? Dilip Das.
36 is one Dilip Das. How
it
he
is
is
my-
allo-
my lord.
how he is allotted. He is selected as space number 87 in the inner railing.
Page number 8. That is why
Yes,
there's a
yes,
specific area.
yes, ma'am.
So you are not there in page number 8.
No, my lord, we are disturbed. We are
Are
already,
you in page number 8?
we are there, but we got disturbed. That is why we approached.
No, what about page number 37? There is no.
37, there is no space is not there.
Huh?
All same, but the space is not there. Even the photocopy.
So you are not allotting a specific space.
And the eviction was done along TRP road. That is the, my lord,
TRP road
northern
is
side
something-
of the market.
ARP road is something different. This is the
Huh?
inner railing of the
Inner
GRP.
railing.
ARP road is something different.
So let them initiate within 1 week.
I would appreciate these were
Initiate
temporary-
what?
Yes, sir. These were temporary concessions given in the year 2020. For 1 year, that has also expired, and COVID time, nobody, no municipal market was running.
My lord, their
No,
place
no,
of,
whatever may be, you see, they have a right to have a vending license. Have you given them the vending license?
Everything like that, I don't think, because survey, if the survey, I will have to get the instruction. I will
No,
have
you have to
instruction.
give them a vending license. Have you applied for a vending license?
my lord, we are given as a category 2 list was prepared and then.
Where
allotment
about that? You are outside?
No, inside. We do fire victim, my lord. How can we outside? They are outside.
No. How are you vending? Are you vending on the street?
No, inside.
So you are inside the
Yes.
municipal area?
Yes.
Okay, now show me what is your right to continue for all times to come?
My lord, our text, what we projected in our
Mm.
repetition, that 450 traders are were there in 1989. Then the market got fired. Everybody was shifted to Maskwa. After that, my lord, 2003 rehabilitation started, and my lord, category 1, who has the license in force, they were given the category 1, and category 2 list was not prepared. Category list are those and the traders who has license is not in force or expired. So now they prepared the category 2 list, and they said that we cannot give accommodation inside the building. We
But
give
but this particular permission which was given was for a year.
my lord, in this honorable High Court's order, there is no specific timing said that you prepare a
Whatever
list.
may be, you have accepted this.
Accordingly, we have to give rent also, but we cannot win the business because somebody street
No,
vendor says they.
therefore, I'm picking up another matter somewhere where how can a municipal property given all that stuff? Without permit? Isn't it here? Then what right they have beyond?
They have, if the municipal does not renew it, they will do that particular, renew it.
We filed it
With the
21,
municipal-
my lord.
Renew
When-
it. Annually, it have to be given.
So it is for only 1 year.
Again, one,
Then what is their right to continue? All that?
all times it will okay.
So
Unless
this is the
unless-
right they are exercising now.
now they are like,
Oh, my lord,
They want them that they should be, once they are an LOT, they remain LOT for all time.
that cannot-
What is their basis? This is a very serious thing.
all the rights are given annually. Annually happy.
Why you don't lead out those things by way of auction?
my lord, that was done, but this.
No,
honorable
auction
court
also has to be for a term. These are public largest.
Yes, auction were done.
Done, but
Auction were done in
Honorable
the
court has
respect of-
interfered this in our instance, my lord, that because
Your instance, this court is now going to uninterfere.
Yes, my lord. Auction,
So how are you doing it?
some shops which are inside the market. Auctions are done, and they are getting it very handsome. Handsome amount we have got it. Because the market value there is very high. Some of the petitions were filed not to get the per square feet in 8 rupees of an 82 price. Later on, it was dismissed and we got it from an 280 rupees per square. If there is auction, there is we earn more money. Auction is a very good option.
Then why you are not doing that?
My lord, there is a
Because
judgment.
you don't do something. They cannot have an allotment for all time. And this is what is being happening all the way. Not here. All municipal markets I'm asking the same question. As for the municipal act, Assam Municipal Act 62 and 63 stipulate what are the municipal property, and you are to sell it for pounds as per the sale of pounds and malls. And if you are selling it, it has to be for a year, and with only the permission from the Director of Municipal Administration, you can make it for 2 years. But here everybody is claiming hereditary, permanent hereditary right. What is your basis?
But there is a section for the anyway. The commissioner can give it only for it.
No, that I know. The commissioner can give it for a particular period. Thereafter, what is the right? If the
Yeah.
period is over, just for example,
Yeah, one.
4/8/2020.
Very fast.
So as of now, this is over. So what right? And why are you accepting it without renewing it? Or issuing a, because if you don't do that, I think it seems that there is a lethargy on the part of the CMC for which this has happened. Or you have if you can very well employ a lot of people out there, because of that you are going to get more amount,
Yes.
but you are not doing it. Something has to be done.
My lord,
If you don't do it, it is going to happen, because you can, on one hand, these are the people who are the allotted, you are keeping and asking them to pay. You are also giving them their right. Everybody is being given a right. Then where will they get out there? They can't vend anywhere properly. And this is the reason why all over India, Guwahati, you are finding people are sitting in the footpaths doing the vending. The public footpaths are, people are, a lot of inconvenience. Unless you have a vending job. When the Street Vendors Act of 2014 has come, and it's very difficult also for this court to pass an order against them because of the Street Vendors Act.
Street Vending Act has come in.
No, because it is, you have not done your task. You were supposed, therefore, to take it up. As of now, if they are not within the municipal property, kindly see, if they are not within the constructed municipal property outside, can you make it a municipal property for allowing it to vending? If you do so, would you not by yourself violating the TMC rules and regulations by the building bylaws? On the other hand, if you allow building, I'm telling you just an example out there. In Big Bazaar area, this Big Bazaar area out there, there were what the Big Bazaar Authority did, they allowed a lot of people outside
I
to
was
vend.
there in particular, I appeared in the case.
Yes,
They were telling
and
this point.
there the GMC interfered, saying that if you allow these people to vend out there, it will be violating the building bylaw.
Setback area.
If that be so, are you not by yourself violating your own setback area?
I have from them. It is a violation.
Yeah.
Setback, how can you?
Then how can you allow any of them to vend out there?
If you strictly follow the pending bylaws, every building should have the setback. Setback, you cannot do business. Then there are some other big organizations that setback, they did business with Baja, then Dona Planet, they were all demolished.
All were demolished.
All were demolished.
But for you, it is okay.
And that's
You can do anything.
it. I have already informed the commissioner that you cannot do it.
Yeah.
The
How can
setback-
you have any business given to them on a setback or side back? This, in fact, it is an allotment. If it is being given to them, it's an illegal allotment. In respect to a property where you cannot permit any setback or business on a setback.
setback business not. At that, whatever 1 minute of what was the violation, demolition for the setback business.
You have done that. And the same parameter does not apply for private, but GMC can do anything. And the very GMC goes in the rule of law
My lord,
to not apply against GMC, but shall apply against.
I have seen it. It is first time I have seen it.
Huh?
Setback, the inner line setback, well, it's really.
Yeah.
my lord, my right was declared, my lord, page 21, annexure B. In page 22, in the earlier repetition, my lord, in 89, there is a second category and they should be accommodated because it is a rehabilitation process, not that you should be given some vending zone or like that. We are there for over the year. Page 22, my lord,
No, over the years, what right do you have?
for fire incident.
No, what right do you have? As per your right has to accrue from an act. What right do you have? Your
Just
right
the-
is only on equity.
We are tenant previously, but our license was expired at the time of,
How can you be a tenant again?
my lord, that is why this court said.
Was
that
it a GMC property earlier?
Fine.
How can you be a tenant?
the rehabilitation process, we are also included. That is why this court's honorable court says that when you rehabilitate also, the category 2 also rehabilitate. Page 23, that is why we are fighting. And that is why sir, preferential right is given, I think. And this is different from the street vendors. Street vendors, they are occupying street, they should be vending zone should be declared, then they should be come inside.
And they are street vendors.
Yes, they are street vendors. My lord, their affidavit kindly see, my lord, their
They
affidavit.
are vending in the near the wall of the old jail. Old jail, not there. They initiated started the business, the old jail is wall of the old jail. Now some construction is going in the old jail. No, my Hafiz Kapoor, he is mixing up two cases together. But that is a different case altogether. Different man. And this is a different
Case-
case. That from there they have started the business. Now they are in.
Page
that
81.
market is run by some other people, man. That is going on, man.
Page 81 of their
I
affidavit,
think
kindly
that-
see, my lord.
Yeah,
What is
always
the
trying
place
to
of
mix up
business? Page 81 of their affidavit, my lord.
Now,
Now they say that we are same boats, brother, means we are also like fire victim, my lord.
I think this is a case which requires to be taken up on a holiday,
yes.
isn't it? Having all the Guwahati and this Guwahati Municipal Corporation, Fancy Bazaar market area, all cases to be taken together and taken up on a holiday, wherein this court can what is called, deal with these matters in later, whatever the consequence, take it later, without spoiling the judicial time of all other. There's no other way out.
Place 81, they have.
We
there is
will have it
declaration that
on.
They are what they are the place of business. is. Now they cannot shift their stand and say that no, we are in a rally.
Let us have it on 11th of April.
My lord, it's a long time we are paying rent.
No, 11th of April is a holiday.
Holiday. Well, it may be a holiday, holiday.
On a holiday. 11th of, no, 11th or 20th of April, 20. It's a otherwise a working day. We'll have it on 20th of April.
Okay, yes.
And you give the numbers of all Fancy Bazaar.
I have,
We will also provide that.
I have provided, my lord, I have
Yes, given.
Yes,
I will add up
Anything, let us
everything,
see.
if anything is
All these matters will be
list,
taken
list
up
also
one day
given, my lord,
we-
and status also
a
given.
copy thereof may kind.
Yes, I will provide them.
Wait, which are, Mr. Purva, which are pending?
My lord, this case, my lord, very few cases, all are, my lord, now settled.
Yes, which case?
Our this case, my lord, only.
6326-2014 pending,
These are not, my lord, withdrawn.
Oh, last
4312,
Withdrawn, my lord. Last
Withdrawn.
occasion for withdrawn,
4502 withdrawn,
withdrawn.
pending, got 7257, pending.
Yes, pending. This is,
Tithi. Then
Um,
this is what? Fancy Bazaar, this is the feast what?
this
This
what,
I have
this,
disposed of.
your lordship has passed a
So
favorable.
this is gone. Now,
Yes, gone, man.
okay, left. is the instant requisition along with WPC number 7576021. WPC number 7556000. What about number 8, serial number 8, 44838?
My lord, this is my lord regarding my lord.
Is it pending?
Inside market
Is it pending?
pending.
WPC number 448 of 2020. Only. Oh, there's no more. Principal,
No, ma.
Last week, 4 cases were.
on 2014. 20. An attempt shall be made to dispose of all the requisitions on the and in the meantime, if you file any more of your matters, fix it on that.
One matters.
Of less bottom.
And you kindly take up that issue as regard what are you doing with the paper? But one thing obviously which you are doing, but it is permissible to have it outside. So in the meantime, the respondent James shall file an affidavit as to whether it is permissible to grant allotment to the various vendors on the setback of the GMC municipal together municipal market GMC and together GMC municipal market. The said affidavit be filed by the commissioner.
For timing. My lord, senior counsel against the sir will appear and to advance their argument. But he's on legs, my lord. So he's coming.
Hello, did
Timing.
you come after vacation? After. Come back. This is specifically checked with me.
Yes, sir.
After again, 12th of March 2020. There is an inconvenience shown on behalf of the learned counsel.
Let's do this matter in which.
Oh, yes. There is the arbor.
In the meanwhile, we have received the
There was
regulation.
amount.
Madam, what is your relief for? Let me.
So the requisition and. Return back to.
Either acquisition or release the landlord. Page 9.
Yes, what did you find out?
Yes, my lord, I have secured an updated report. Now, this says, my lord, that now the dispute is with regard to that tag number 770. How come it has become government land? Now, that cannot be found out, but it has been stated here in that, my lord, that that particular tag number 770, it was, my lord, Nihati Patta land of the petitioner. And later on, it was changed to 3340. Perhaps, my lord, because of the reason, my lord, during the
It has
settlement,
been under the occupation of the government and as such they showed it to be government.
maybe, yes. Because, my lord, in the resettlement operation, this revenue staff goes for still visit. Now, perhaps that may be one reason which we have discussed along with the deputy commissioner. This appears to be the most plausible reason. They go for, my lord, site visit. They found, my lord, that TMC, my lord, campus and part and parcel of that land. My lord, it was comprised within 770. But perhaps they were not aware about this requisition proceeding. They found it, my lord, so they stated it to be government. Lordship may produce this, my lord. I have secured the report of the calculator as well as, my lord, the trace map and the, my lord, earlier.
So
the-
therefore, when they saw the trace map, they found out.
Yes, trace map is also available. I have secured everything and the whole Jamabandi also. Okay, you go. Now, in the earlier report, which is part of the record, Lordship has seen it, my lord, the earlier report.
But in this case, অধিগ্রহণ কৰিব খোজা ম্যাদী মাটি, খেয়াল মাটি, but this case,
Yes, my lord, that was, my lord, at one point of time, my lord, it was requisition. Now, Lord,
no, this is the land.
yes, this is the land. And my lord, there is
Now,
a,
if you see this land, 772, 770, and what is this in between that other land? 770 and 77. Your land was 770 and 772.
now, my lord, so far as 770 is concerned, my lord, they have annexed the record of right. That is, my lord, Jamabandi. Now, so far as 772,
No, it is there. The Jamabandi categorically shows 770.
in the,
770 say Tagore Kandi hol tini bigha.
no, my lord,
772 is 4 bighas, 2 katha, 8 lakh.
no, yes, that is true, my lord, but whether they were the recorded pattadas, their predecessor interest were recorded pattadas in respect of 772 also, my lord. That perhaps, my lord, is
Now their name must be there. What is the name?
there
Kumar
now.
Jatindra
Jatindra Narayan
Jatindra
Chaudhary is
Narayan.
the predecessor in interest. In one Sikha lordship will find it is handwritten.
No. Whether they were there or not, that is immaterial. But the fact remains that these two lands are private.
It's to let the private right.
No, now
Yes.
the therefore,
Yes.
when you issue a notice under section 6 or 9 of the Acquisition and Requisition Act, you will be issuing notice and they will have, whoever wants to make a claim, they will make a claim. That's a different aspect. We are not concerned with that. For that, they will look into it. But for that, you need to acquire.
Yes.
But the
Now,
fact remains that these are not government land.
so these are not.
So if these are not government land, you can very well go ahead and
Yes,
acquire.
go ahead, only, yes, only with respect to, because of the fact that, my lord, on the last occasion, I had submitted a report from the additional deputy commissioner. So it is called for a status report. Here, my lord, in the second page, in the tabular form, my lord, here it was written 770 as, my lord, government land.
That I
Therefore, lordship directed me to, take that
now, if you see, in this street map which you have given,
Yes.
from 770,
Yes.
there has been some bifurcation.
from 770, my lord, the new DUG number 3340 has been
No, no,
created.
3340 is okay. But
Yes.
what is 3350 and 33549?
3350 and 3349, they are also created, my lord, from 770 and 772.
Now, it is in whose name?
It is, my lord, only, my lord, 770 appears to be in the name of the predecessor in interest of the petitioner. My lord.
These particular land,
Yes, my
3340 and 3350 and 3349 is a
Yes.
part of 770.
lord. Because
Earlier.
770 was a big
So
area.
therefore,
Yes.
from this 770, it
Yes.
was bifurcated into 3340
Yes,
and 3350
Yes.
and 3349.
yes,
3350 and 3349 are very small portions of land,
Small.
whereas 3340 is the bigger portion.
absolutely. And therefore, my lord, in the requisition order, my lord, which is also a part of the requisition, lordship will find that the requisition 770 that means there is, my lord, 770 also. If there may be, my
And
lord,
this data is
Yes.
of 3340.
Yes.
Where they have made it sorry.
there-
So when are you going to make remedial action?
now there is one order lordship will see there. It was first waived in the year 1999 in the concept of letter in the letter part lordship will see.
1991, 99.
1999, yes, that order lordship will kindly pay. Because of tendency of an urban land ceiling case, and there was a proceeding before this honorable court also. It is only for that reason, my lord, that it got, my lord, left here. It is only for that reason.
Then what happened?
Then, my lord, updates are not available.
But it didn't go for a ceiling.
Yes.
This was done under the 71 Act.
Yes.
Urban Land Ceiling Act.
Urban land
So that
ceiling.
has gone. So nothing happened. So therefore the land is there.
No, my submission is that why so late? Why we are so late? At one point of time, my lord, the proceeding got my lord stuck up because of that, my lord.
That proceeding started in 76 and you did not dispose of till 99. What is the wrong? No, that is immaterial. You have now, when are you going to correct the chita? Because without correction, the chita, you cannot go ahead. So when?
Lordship will pass a director, my lord, because they are also totally confused. I had a sitting with the additional deputy commissioner, all the records. 770, then my lord, 3340, my lord, change. Everybody can see it, but what prompted, my lord? What is the reason behind that? No one is able to set it up. And we are only on
Same
the,
thing.
my lord, that 770, how it has become government.
No, that keeps on happening because of the executive excess. I can use executive excess.
Because these are
Today I had passed a direction in one of the cases. So the success story.
because initially, my lord, in this matter, I also got totally confused, my lord, with all, I was humbled with all these documents. Then, my lord, I got came to know, my lord, this 770, at one point of time, it was Patale. Now, my lord, it has been changed. Now, the reason which appears, most plausible reason, maybe, my lord, because of the fact that the revenue staff
at the time of resettlement operations were not aware about this requisition process.
Not only requisition,
No, no, requisition process.
what he did,
Yes,
he went and made the field verification.
Yes.
And made it that,
comment
that
that.
now that
Yes,
this
that's right. Yes,
medical college is there
yes, yes.
and medical college
Yes.
is above everything.
Now, that appears to be the most plausible reason. Of course, my lord, I am on redemption. Because even first direction, my lord. Otherwise, now, my lord, everything has been cornered out. My lord.
Pursuant to the order passed by this court on 7/2/2014, 24. Mr. R. Babu, appearing on behalf of the Revenue Department as well as Revenue Department of the Government of Assam have placed before this court certain instructions issued by the Additional District Commissioner of the Ethics. From the state instructions and the documents enclosed, it reveals that tag number 770 and 772 of Patta number 32
Yes, madam.
of village Daporikut
Number 2,
number 2
Number-
Moja Belkola
my lord.
contained a plot of land measuring 7 bighas, 2 katha, 8 acres. This particular plot of land was the patta land of the various pattadas whose names have been included in the Jamabandi. There is a revenue map further to that. In respect of dark number 727 and 769, covered by patta number 268, the 284, of village Daporikut, number 2, Moja Beltola, is also a patta land. Consisting of 3 kathas, 10 lectures of land. Seven to seven, 7 6. This court also finds it relevant to take note of that the land included that the land which was requisitioned is a plot of land at measuring 8 bighas. This is 2 kathas.
Now, in the requisition order, Lord, you find 16 meters. No, no, that is the total quantum of land. So far as 770 is concerned,
No, not 7 7. We are concerned. No, kindly come to this map.
my lord, that only I had only one.
No, what does it show? 8 bighas, 4 kathas, na?
Right.
As per Annexure C, page 16, Lordship.
No, kindly show me this one.
I'm sorry because I received it.
No,
late, my lord. I
four
couldn't-
kathas or something.
my lord,
What is that symbol? Four kathas,
Yes, LP got three.
three or four? Three is different.
No, yes, it is four.
Four.
LP ka four kotha, 18 letter.
Four kathas.
This is four, my lord.
Three is in a different.
Three is different.
Eight figures, four kathas,
LP ka four kotha, mane 16.
four katha, 18 letters.
18, my lord.
It also repeats from the trace map as has been prepared during the resettlement operation. That dark number 3358 is culled out from dark number 772 and dark number 3340 has been culled out from dark number 770. The record also shows that in the recently prepared kitab, the survey today, this dark number 3340, which was all along a Patta land belonging to the Pattara, have been shown as common land. And there is no justification to the said aspect. In fact, the instructions which have been placed on 14/2/2024 also makes it clear that the district administration is not aware as to how dark number 770 old 3340 new
Yes, my
became a common land. It may not be out of place also to mention that this common land, this preparation of the record of rights of making dark number 3340 as a common land is a recent phenomena taking into account the recently concluded settlement proceedings. This court, however, also finds it pertinent to mention from the records that it is on account of this wrong insertion of dark number 3340 as a common land. The same is acting as an impediment in initiation of the land acquisition proceedings. Consequently, it is the matter on 13th of March 2024 to be listed at the top of the list and shown as part of. On that, the responding authorities, more particularly the Deputy District Commissioner of Kamrup Rural Metro, is directed to ensure that this correction is duly carried out in the record of rights and the same be placed before this court on the next day. Further consequential directions as regards the acquisition shall be passed on the next.
Approaches, they retain it with a mark, my lord, I think.
What took place during the course of the hearing is kept on record and marked the letter Z.
I'm obliged.
Mr. Bapuzari, you see, there was one, when I was a lawyer, there was one, I have the Mohoris, huh? I was confused as to how you find out the dag, present dag with the earlier dag. How do you- Then he took me to the settlement office just to show me. I had nothing to. And then he showed it from the Kanungas, that map, and then pasted the new map on top. And then to find out how these that they have a very big map. From there you take the new map or you put which are the dark which have been.
Which have been, my lord, yes, and that doesn't. Until my lord, there is no allocation and delusion because it is.
Otherwise you cannot make it out from the record of right.
Absolute.
It has to be on the imposition.
Absolute. Absolute. Now therefore government has come up with that, my lord, drone technology of late, because this practice may not be feasible for Sarasman, but the chances of manipulation are there. Drone, it is drone.
But the only thing is,
Yes, the lordship is correct,
yeah,
but
this
it's a
is
very
how you
clear
find out.
affair, yeah.
That is why it was not difficult for me. The moment you said that, I said,
Then we have to visit Mahapesh
there only you can find it.
Yes.
No, at that point of time, it was in the settlement office.
Settlement
So when I went out there, I just went to learn how it is. How can you find?
Settlement office. Yes,
It was not there. It was in the dispute.
yes. Yes, so
Yeah,
this is
even-
there. I'm obliged to.
Oh yes, this one.
My lord, in this case, my lord, I have filed an IA to implement the respondent, my lord, SPOC, IC, and the station officer as party respondent person.
For what?
Because, my lord, the letter was issued by the deputy commissioner stating, my lord, the police report and fire report is required. But I could not make them party, the police and the fire officer. So I have filed the IA, my lord. And today listed along with the report.
For what time?
Yes, my lord. For
What you have proposed?
But in fact, we have filed the affidavit and we are opposing the petition on the ground.
That you are opposing.
Look,
I have to-
But
Because there was no fact.
the incident took place in the year 2015. And the OC and he has now prayed for implementing the OC and the fire officer. Because the earlier also we filed an affidavit and at this stage, the factual dispute better he has to approach the civil court. Ultimately, the fact has to be
Right.
My lord, in this figure, my lord, the police
and
report
since
is
the-
there, my lord.
Since the
No, no,
repetition
no.
is
This report they are.
My lord, and that part, my lord, the endorsed by the fire official, my lord. Yes, my lord.
Okay. It's not. The report. Why the report? The main. The kind of good. Because
But-
you see, the question is, they have categorically said that there's no fire.
That is not said, my lord. They said, my lord, no record is found in the fire office, my lord.
Deputy
But the police has not submitted the report, my lord.
It also have
Report that,
paid,
but
they have also said
no police
categorically.
yes,
the
my
activities
lord.
of the response of the fire
and the circle officer also submitted the report, my lord, stating fire accident, my lord.
simple on the body of the here before the report.
My lord, page 59, the circle report, my lord. And
Sorry,
the police report, my lord, I have
eating board of requested,
my lord,
they were rejected their
not yet rejected, my lord.
The documents are not available. That is why we could not consider his case.
Not yet rejected, my lord.
That's what- on the basis of
I am
available
not
material.
saying any.
Yes,
I will say that Mr. Smith submitted the picture of the paper to release public provide rehabilitation grant of the compensation like financial assistance to the petitioner in terms with the notifications of the letters dated 27/7/2011, 8/5/2015 and 2/5/2015. The ground on which the petitioners have sought for the financial assistance or the ex gratia grant is on account of a fire in the CIC house of the petitioner due to electric shock petitioners claim on the basis of a police report dated 1/5/2015, wherein it has been mentioned that due to an accident, the fire was set from the kitchen roof and then the house of one Mostab Ali, as well as the houses of others were gutted. The respondents have filed their affidavit categorically denying that there was any report being forwarded by the fire department. Fire department.
Yeah.
As was required. Fire and emergency service station as is required for the purpose of consideration of the said application. Further to that, it was also stated that the applications were incomplete for the following reasons. Number one, non-submission of clear fire and emergency service report. Number two, non-submission of photographic evidence at all, comma. From the materials on record, it therefore transpires that the facts alleged by the petition have been seriously disputed by the respondent authority. The question therefore arises as to whether this court, under such circumstances, can issue a writ directing the respondent authority to disburse the amount of entitlement as sought for by the petitioner. This court have also taken note of that the said applications filed by the petitioner are pending before the respondent authority. And concerned respondent authority, and various deficiencies have been pointed out in the affidavit in opposition. So, taking into account that the said respondent authorities would be in a better position to decide the entitlement on the disputed questions of facts, this court therefore disposes of the instant petition with a direction to the respondent petitioners to thereby granting a liberty to the petitioners to approach the respondent authority by providing the necessary documents. In addition to the documents which were duly placed, and thereupon the respondent authority shall decide on the entitlement of the petitioner. The said exercise be completed within a period of 4 months from the date of submission of the instant certified copy, along with the other details, other deficiencies as set out in the affidavit.
Number 5. Notifies that respondent authority. Instead of that, deputy commissioner, respondent number 5.
That copy they are to the respondent.
Deputy commissioner,
District commissioner.
district commissioner.
Obliged.
Well, this matter is unnecessarily hanging on this, filing this application, that.
So he will, by passing the speaking order, he will.
Where is the court?
I am for respondent 5. 5 degree. No, against the degree filed by petition. Taking the stand that having 2 residents, one from district without, and another by that what. And so far, my daughter.
Affidavit filed
Today, my
by respondent number 2.
2 has filed, 3 and 5, 3 filed yesterday, a day before, 5 filed today, this morning, doctor. And he has given new documents here.
Who document and
New documents have been enclosed.
Huh?
New documents have been given.
So what do you want?
I want to go through the documents, doctor. I'm a little confused with the documents because the government did not give us those documents.
Who has given you those?
He has given new documents today.
earlier,
Mr. Bhuya has access to all the.
but if for the document, the texter is concerned, only one page provided.
You are with the.
That's number 2. I am correct.
No. you are
Five,
not-
five, five.
I'm respondent 5. But
Are
earlier,
respondent five.
respondent number 2 provided this only 1 page. But this order consisting 9 pages, and signature appeared on the last page. This contention raised by the petitioner.
Your name is who? What is your name? Mr.
I-
Bhuya,
Tajuddin
your client's name?
Ahmed.
Huh?
Mohammed Tajuddin.
Tajuddin Ahmed. Oh, that one. where you are doing it from West Bengal.
Kolkata. Kolkata.
Kolkata. My lord, but Lord, you are contented that these
You are
orders
doing for? We did. Oh, yeah, at last you have it here. The fight you have. Yes. So you are otherwise qualified?
He thinks.
Where? Which one? 2 1. The following documents are be submitted at ready to be okay. No, her contention was 2.2. Work experience of work at the provide service 500 connect. Huh? Where is your 100? 190. 192. Yes, what is it? Notice of enlistment. 94. So this certificate was a part of the documents you have submitted. 29/5/2023. What was the last date of submission? Last date 35.
35.
Prakash Enterprise. This is this is a Prakash Enterprise, not a Pudhan. Where is this became only on 29/5. These are work pertaining to earlier period. At that point of time, it was not Prakash Enterprise. Mr. Counsel, you see, this document of joint venture was entered into between you and Prakash Enterprise on 29/5/2023, just one day before the agreement, submission of the last time. Now, on that date, you had the joint venture. Then how could you take this into consideration of these works of 2019 of Prakash Enterprise? Or did you submit as a Prakash joint venture? Both are parties. Where? Oh, it is being given to a joint venture. has been given, so you are qualified. Then comes Tajuddin. Yes, Tajuddin, what do you have to say?
No, Lordship,
Lordship, so far,
I'll
my lord,
submit
the
later.
mandate is concerned, clause 2.18 and as well as 2.2.1. Lord, I have fulfilled all the criteria.
How?
And my lord, for my activity is concerned, my lord, total 5,447, my lord, water connection will be complete. On record.
Where is your affidavit?
Affidavit, my lord, file on 18.1, my lord. Page, my lord,
Okay. Yeah, this one, 138.
page, my lord, 60,
First affidavit.
61 is,
Ahmed.
61 is my registration certificate. And page 62 turnover.
No, we are only concerned because her submission was only limited to that these people are not at all approached with anybody. Then how could they supply? Because in the criteria which have been followed out here, kindly see a page. There is the criteria. In which the page
In this petition, page 32, my lord, cited.
It's certificate.
Proof of registration with Assam PhD, PhD or GMC or GMD or any other gov
Tajuddin, yes.
or any other gov. Clearly. And I have my lord registration certificate, my lord. That is my lord, page 1.
So, madam, what is wrong now?
Now, Lordship, I'll just take your Lordship. First of all, the affidavit which was filed by the respondent number 2.
Hmm.
The first affidavit, Lordship, has a specific statement. Ours, we claim 4,900 and something, 200 and something as retrofitting. Now, Lordship, the respondent number 2, running page is 68. Sorry, running page is 67.
Huh?
67, the respondent number 2.
Respondent number 2's affidavit it starts from page 167. Yes.
No, that's the second one. Is file 1 opposition, where they did not annex the document. This affidavit only
Oh,
annexes.
respondent number 2 is who? Oh, them.
Yes,
They have filed some affidavit when?
they filed their affidavit on 13/10/2023.
You are referring to the first affidavit?
First affidavit they have filed.
Yes, what is it? Page?
Page, I am taking Lordship straight to. Oh, they talk about decor. I'll not go there. Lordship will come to page 68.
58.
68, running page 68. And they told me why my fishery is not allowed, etc., etc. Then they say at C, subpara C, that as the criteria is specified for providing house service connections, that retrofitting work under JJM are not considered. This implies that to all the bidders, out of 4321 numbers of house service connections as claimed by the petitioner, 2901 is retrofitting.
Hmm.
So, Lordship, they have removed retrofitting from ours totally. You are not qualified. But now, Lordship, if Lordship looks into my second affidavit, where I have given the particulars of additional affidavit, after he give me the documents at running page 99. So, Lordship will find for respondent number 5, 3.
Respondent number?
3, this is 3.
8.
I'll just, that's too many. This number 3 is the affidavit. Oh, Lordship, even my affidavit, I think I've explained everything. Which is my affidavit will show everything. If Lordship looks at the work experience, this is running for page 111.
112.
111, work experience. This is the work of experience of respondent number 3. Purvanchal. Lordship will find the first serial. It is for This Kokrajar, Lordship will look at the description of the work. Arsenic mitigation scheme on turnkey basis. This is arsenic mitigation, Lordship, not house service connect. Then again, the second one is also arsenic mitigation scheme. Arsenic mitigation scheme on turnkey basis. Now the certificate which he has annexed with his document also talks about 1900 household connection given by the executive engineer for this arsenic mitigation scheme, not house service connection. And Lordship will look at the next. One. Retrofit.
ZZME,
Jal Jeevan Mission.
Jal Jeevan Mission.
Jal Jeevan Mission.
here there is at number 813. Implementation of Samudya pipe water supply scheme for retro. The job. They have taken into consideration this effect.
They have considered retrofitting for them. For my case, they say it's bad.
Other 500 minimum connect. They have it.
That's besides the point. The number of connections I'm on.
No, anyways, whether the mark will change. Here, okay, but are you giving not the marks on the basis of the work experience?
The formula applied can the mark make it. I thought
Huh?
there's a formula.
What formula?
Page 32 of the repetition. When I think of there is a formula.
Yes, this is the formula, yes.
Every
15
person will
marks,
get
15
it,
marks.
then it will be calculated, divided, and there is a
Average turnover, we are not concerned. We are concerned with 30 marks.
formula.
A. What is the basis of 2A? It will be multiplied by highest value all figures meeting some qualification requirement with the reported maximum marks. Example for A. The highest numbers of instances say 500%. All the marks given to form A is 30. Number of 5.8 4,000. Grade A 30. 20. So you have not considered the petitioners here to the extent of 2,900,
Yes, sir.
2,901. You have not considered.
Retrofit.
Retro. Now, have you considered the others?
They have. Work order ko hai.
For respondent number,
Three. The work order is this. Yeah, full page was the mark for your purpose. There's the work experience with the
You are T. Kumar. Oh,
Is no, Dikumar is not there. Dikumar is out. We have not. Where is it?
Of the petitioner
Respondent
number
number
3, it
Respondent
is
number
5,330. Of these 5,330, all are not retro-speaking.
Okay. So when he gave the work experience, work experience, this is when you go, it's marked in minus. Take out nine, it's marked in minus. Then it's marked in minus. Here, to more repetitive starting to 111. Then this two are arsenic. Are they arsenic? They are not outside. Then you come below Then this is retrofitting. All these are retrofit.
5477 of Aditya Appiah. Okay. Yeah. Show me your experience, your affidavit.
This is not work experience, work order. What is supply? Retrofitting. So, retrofitting. और अच्छा मैं देखा है this is work experience retrofitting है तो page 155 this is retrofitting 155 retrofitting and 155 is what do it a retrofitting do it a retrofitting 155
water house dot
okay retrofit
it was five
55
I got 25 prior to last date in and provided 877 all together
What is your additional affidavit filed on 30th of January?
my lord five
where is this work order
now I clarify about the five since the
okay
clarify
Sir,
I have
the Bora kindly come to page 102. Get the board sheet. Boom.
152
Just to one unpre-entered text.
Nectar 1. Nectar 1 is the document.
this is country enterprise
Now, kindly come to page 153. Isn't it retrofitting?
Confusion regarding pagination number.
Huh?
Confusion regarding pagination number. That's why I cannot.
That is your lookup. Will say that you have not been able to assist this court to show properly. JMF. That's the implementation of high water for retrofit ongoing Jal. This is how many correct? Then X is also retrofit.
everything is retrofitting lot
Yes. What is your basis to hold that he had 5,350
Number 3.
Huh?
Number 3.
on page 152 of your affidavit filed on 30/1/2015?
Page number 154, there is 1,900 numbers of logical notification. One 143, 3,430.
Next,
Page number 143.
43 Act is not a part of the document. 133, 143, no. 143 is he.
Yes, I believe.
143 affidavit edition will be filed by the phone number 2.
No, your affidavit filed in additional file by responsible to is at start date 144.
144. Your affidavit is 130.
Okay, there you must have put the number as 111. Now find it out from there. On 1st of February 2024, you have filed an affidavit. Do you have it?
Yeah, it starts 111.
Okay, 111. Now therefore come to 119.
119, there is putting all these things. In page number 134, there is connection of 1900.
Huh?
1900.
Yes.
Then this 1900, but will also turn to page number
No. Kindly come 134. You see,
130.
presently they have successfully completed 1900 of functional household tap connections under so-and-so minor matter or so-and-so. Yeah, and under this. Now this thing you are referring to at this. Kindly come to page 120.
120, the work order.
Here the reference of here is in serial number page 120, number 2. This is the implementation of Minamata Pathar pipe water supply scheme for retrofitting. Well, how can you take this aspect? Yes, Mr. Betala. These works at page 194. Are these retrofitting? Huh? Page 1. Yes, that is it. Where 3000? This is the work, if it is taken into consideration, the petitioner has been deprived of this. That is the issue. The petitioners, 500, no, petitioner have been not taken into consideration. Petitioner also had 500, you also have 500, but the petitioner gave around 5,000, of which only 1,330 has been taken. 2,900 has not been taken because it was retrofitting. Now, if this is the consideration on which it has been done, then it is wrong. Because this is retrofitting. Look at the stand of Jal Board, where petitioners 2,901 connections have not been taken into consideration. No. See their affidavit which they filed. No. Kindly see the page 68 of the affidavit filed by the government. That as the criterion is specific to providing house service connection, that retrofitting work under JJM were not considered. This implies to all bidders. Out of 4,321 numbers HSC has claimed by the petitioner, 2,901 is of retrofitting. No, there is no fishery business out there.
This is the
See
work.
number C. Then. So it is the categorical stand that retrofitting would not be taken. And if they have taken it into consideration as regards the other bidders where they say that they have not, wouldn't that be? Then the calculation has been, the marks awarded will be wrong. Because the petitioner only hinges upon the last, is number last. So one, if it is, if a person goes out from there, the fact that you, both of you are now, because I kept the matter only alive, otherwise I would have dismissed it on that occasion when I vacated it. Kept it only alive as to whether you were, both of you were technically qualified. Because you did not, it was shown that you had the air with some electricity department or anything which had nothing to do with it. So that was the basis. But the question is as to whether the retrofitting is removed of all the bidders, then would that impact on the valuation of the
But so far my over
No, yours, there is no problem with retrofitting. But if that retrofitting is there, and most of it is retrofitting, would he be entitled to this? Because 30 marks is the main entitled.
I got time.
Yes, Mr. Bora.
Retrofitting has not been taken consideration.
Huh?
Retrofitting regarding petition has not been taken into consideration.
No, you also say that all the pages retrofitting has not been taken in. You see, that retrofitting work under JJM were not considered. This implies to all bidders.
Yes.
Meaning thereby you have categorically stated out there that retrofitting was not taken into consideration. Now, whether the retrofitting, if not taken into consideration in the case of Mr. Betala's client, would it change the equation? Because this is the main thing is 30 marks. And if, or on the other hand, if you consider it, hey, and you consider 1,900 of the petitioner, now, could the petitioner come to within the ambit of number six?
That calculation has to be done. That is that calculation has to be. Because earlier one calculation has come up, but the directive to make a recalculation.
That I have done, that was in fact,
Enhance the position of the petition.
because the petitioner stands at number 6. You have given it to 5, na?
7.
Seven.
You have given it to 7.
6.
You have given it to number 6. So the petitioner is number 7. Now the petitioner is only inches away to get it. But whether, if you consider a retrofitting, would the petitioner come with it?
Then the whole calculation will change.
It is your fault that you have to do it because your categorical stand you have not. Now if you remove the retrofit, because the petition, all the bidders seem to be qualified. Now therefore the question is, if the retrofitting is not taken into
If
consideration,
not taken, also not be
all.
taken, or if taken, also.
then whether the petitioners as well amongst the 6.
Then, Lordship, even the work experience, work experience, my fishery department, they have not taken it as work experience. But in case of others, even for PWD work, which is road construction, they have taken that work experience with. So that also have maybe looked at.
What the thing is wrong? What is the something different? Whether It's a clause.
Madam, have you filed your affidavit
I filed all my affidavit.
against them?
Just now he has given, I got it just
Today,
Today.
evidence.
I'll file it. Lordship, I may file a composite affidavit.
A composite affidavit giving your
I'll file a composite affidavit matter giving all the details. I'll make it a chart.
and also say
Because
the
these are
question of now all the bidders being not qualified does not arise.
No.
Question is as to whether the evaluation has been done properly as per.
Yes,
If
absolutely.
it has been earlier, there was some mistake where certain things was not taken, for which then also you are at number 7. Now, whether you fare within the 6 is the question of.
Yes.
So that we need to dispose of the matter for you because otherwise the
Others
work
will
will
just
be
carry on.
completed.
Lord. It doesn't help me at least. It doesn't help me at all. So Lordship, whenever next 13th of March,
Yes. File your affidavit.
I'll file it
To
within
the detail as to how the calculation.
everything of each.
Because this court will only direct them to recalculate, nothing more than that. This court is not going to say that you should be given this mark or that.
No, at least it will send a message to the authorities to act fairly.
And then.
That is what I want. Because
and
this
then
is what
to-
happens. This is what happens in today's world. Let us
No, the Jalbat
Please,
has
no, please don't.
categorically come up with a stand that retrofitting we are not done.
Yes.
If they are saying that, if they stick on to this affidavit out there and thereby excluded the petitioner of 2,901, which would obviously, if your thing is taken as 5,350 and he is taken with 4,321, our marks would obviously come up.
And he's will.
Then why did you submit for other things turnkey, which had no business out there? Finally come to page 195. 196. The execution, testing and commissioning of Mainamata Kothar so and so arsenic mitigation scheme on turnkey basis. How does this have any relevance? Execution, testing and commissioning of Nimua PHA under so arsenic mitigation scheme. Is there no business out there? Then implementation of Mainamata Kothar pipe water supply scheme. That may be have relevance, but that is retrofitting. Then implementation of Nimua pipe water supply scheme for retrofitting again, that is also ongoing, both were ongoing. Then implementation of Uttar Khartoia pipe water supply scheme for retrofitting. Then implementation of Uttar Hamdanga pipe water supply scheme for retrofitting. Balance work of water supply scheme of habitation under so-and-so Bakeli DP of Guwahati division under program so-and-so during 2016-17. And the best part about this, do you see this? Kindly come to page 198. The last one from the bottom. NRDWP, Chief Engineer. Balance work of the water supply scheme facility in habitation under so-and-so of Guwahati division under program so-and-so during 2016-17. And see the date of the contract, 2019. Contract of 2016-17 given in 2019. Implementation of different pipe schemes under so-and-so, this is retrofitting. Then again retrofitting, again retrofitting. So,
I mean, that activity compile a benefit. I meantime, I will take the photo of that particular destination. I am going to.
you do it. Today itself, ask your junior to do it. The
I
record
filed a-
reveals that various pleadings have been filed. And the last of such affidavit have been filed by the respondent number 5.
This morning.
Yesterday.
This morning.
This
morning.
Today.
Filed by the
First of the learned counsel appearing on behalf of the petitioner submits that she would like to file a composite reply to the various affidavits filed by the respondents. Liberty is given in that regard. This court further take note of during the course of the hearing, Mrs. M. Hazarika, the learned senior counsel, has drawn the attention to paragraph number 17C of the affidavit filed by the respondent, affidavit in opposition filed by respondent number 2, wherein it was categorically mentioned that as the criterion was specific to providing house service connection, the retrofitting works under the ZZM were not considered. It was also mentioned that the same applied to all the bidders, and consequently 4,321 numbers of HSC as claimed by the petitioner, 2,901 was retrofitting. It is under such circumstances the petitioner was given the marks at 15.45 on the basis by taking into account that the unqualified bidder, one D. Kumar and Company, was given 15.45 marks. The learned senior counsel has also drawn the affidavit in attention of the court to the affidavit in opposition filed by the respondent number 5, as well as the affidavit in the additional affidavit filed by the respondent number 2, wherein the work experience of the respondent number 5 was duly mentioned. The learned senior counsel had pointed out that most of the works of the respondent number 5 pertain to retrofitting, which, however, were taken into consideration, whereas the petitioners' retrofitting works were not taken into consideration. Mr. Espora, the learned counsel appearing on behalf of the respondent Jal Board, submitted that he would obtain necessary instructions in that regard and place the same by way of an affidavit.
Yeah, that's true.
Three good. One, three good. Very good. Affidavit of respondent. Had looked into the respondent. On the type of. List the matter again on 30th, 14th of
14th.
March.
14th is a Thursday.
Thursday only.
Oh,
You don't want the matter to be done, or you want this matter to be pending out.
so 14th is a Thursday, March.
14th.
Yes.
On 14th of March 2024.
Okay, basically, not on 40, any other day, except 40.
Any
It is
other
well, man.
Well, on 12th of March 2024. We'll have it on 19th. Too many matters on 12th. On 19th of March 2024. The affidavits by the petitioner, as well as the affidavit by the petitioner, as well as the Jal Board, be filed on or before 15th of March 2024. Yes, what is this?
Hello, the petitioner challenged the alert. Order of my lord, operating the canteen, which was for a period of 1 year, by way of tender.
No, it has become infected.
That-
None appears on behalf of the petitioner on call. Mr. T. Sharma, appearing on behalf of the IOCL, submits that the 10th order which have been assailed is in respect of awarding the contract in favor of the respondent number 5 for a period of 1 year. 1 year, na?
1 year.
The said period have already lapsed and there was no order of stay granted. So considering the above, the instant petition has become infructuous and accordingly.
Okay.
Yes, Mr. Goswami,
Yes, yes, as directed by the town, I have also got.
you got some certificate as to whether they got that
Yes,
money.
something has been done by the authority.
They, Mr. Goswami, tell them that this vote is because status of the inquisition proceedings as well as to what step they will. Mr. Chauhan, you have not
Yes.
paid the deficit for
My lord, I have paid, but my lord, today, my lord, I have received. I have received.
you have got your instructions.
Public,
Yes, what is it?
make this. Make this. Okay.
It is done under what provision? Under what provision you are doing?
Except what is stated in this letter, except that, my lord, I have no instruction on that, my lord, because today morning I have got it. I have done it. In that regard, my lord, I take instruction. At least authority has done something as directed by the law.
But you cannot have this
Yes, yes,
estimate.
I understand.
This estimate is wrong.
I understood.
This estimate cannot be, you can't make the estimate as per your old act. Because we, in 2021, you cannot do that. And how can you have, first of all, the concept of having it for these LA cases, one of 2002 of 2004, these were done under what provision?
That 64 Act.
It
That
has to be now as per the new act.
Notification is also with us.
Huh?
Notification of that type. Under
Oh,
1964.
these are done under 1894.
No, 1964.
No, kindly see an example.
I got,
These are done under 1894. LA
Before-
case number. The amount. The 1894 act.
this is the notification.
Where is the notification? These are all 1894 act. 1894.
Now in therefore, in person to section 9 of the Assam Land Acquisition and Acquisition Act 1964. Annexed 2 of the our act.
Affidavit.
Yes.
When did you issue? Gazette notification for acquisition of the scheme RX. Delhi case. Assam acquisition.
Last phase of the affidavit went up. In fact, earlier, amount of rupees 63,46,781 short for. Now it has been raised to, my lord, I think 14 crore. 14 crore 29 lakh 1,340.
Now, the state government has come up with a notification stating that in respect of all acquisitions done under the 64 Act, they will make the compensation in terms with the new 2013. If that be so, in view of that notification of the central state government, now you are to therefore apply that particular thing.
I have to satisfy your lordship in that. In that case, I have to satisfy your lordship based on that. Because your authority has furnished a copy of this communication. I have this product. So in this regard, certainly I have to clarify all these things better.
Because otherwise,
Yes.
Mr. Goswami, there is one concept.
If notification is there,
So I
certainly
don't like that concept, but that is a law
Might.
which has been
Right,
declared by the Supreme Court. The case of Bangalore Development.
Yes. Yes.
Wherein the concept of by legislation of incorporation, if it is done, that
we have no
provision
alternative.
would hold the fee.
We have no alternative.
Huh?
We have no alternative.
Then in that case, the Act of 1894 would hold the fee. Now, if the Act of 1894 would hold the fee, and more particularly if you take section 6
Of the
of the
Of that
64 Act, 64 Act, can you, which stipulates that if you have to do under the 1894 Act, would the proceedings not lapse in view of section 6 mandating that you are to give your declaration within 1 year or the award to be passed by 11A 50 years? Get it? Secondly, even otherwise also, if we see section 6, 11
of the
3,
64.
11.3, where the compensation has to be determined under subsection 1 or subsection 2, the collector shall make an award in accordance with the principles set out in section 11 of the Land Acquisition Act, but no amount referred to in subsection 2 of the Act shall be included in the award. So their interest was not there, but later on the Supreme Court categorically said, to keep this Act alive, that okay, we will give you the interest out there, the interest, but it will be in terms with the principles of 1894 will apply. Now, if the principles of 1894 will apply
In respect of payment of interest.
in respect of not only payment of interest, the award also has to be made in terms with that. And you have come up with a notification to the effect that in respect of all these matters under this, you will be guided by the determination of compensation will be done as per this.
Anyway,
Then now can you say that no, we are going to go as per the 30%? This is a very important thing.
question to be considered by the
Although you have a similar provision, 65, this is the 64 Act, the 65 Act of Nagaland. They have also the Nagaland Acquisition and Acquisition Act, where the role of there as to whether the petitioner therein would be entitled to compensation as per the new Act of the Code. I held that in view of the categorical mention of there that the word that is brought up comes in section 11.
of their 65 Act.
65 and 64 are same. 11 has to be as per the market value. If you read 11, it categorically says it will be as per the law. So if it is to be done as per the law would now be the. But however, you have been filed for another question out there in that it has been stated that in Nagaland, they have till date, because Nagaland falls in the sixth schedule property. Being a sixth schedule, unless the governor accepts it, you can't incorporate the provisions of a central. So that is another aspect on a, but otherwise that this court have,
has to be adoption of the act.
so that is another issue. Anyway,
But what I am pointing out, my lord, as party, my lord, annexure has paid state to the affidavit matter. That is earlier it was 63 lakhs and something. Now it is 40 crores. Demand was placed for 63 lakhs 46,000.
you are calculating at rupees 20 per bigha. Deduction of conversion. Per bigha is how much? 2,50,000.
March rate of that one is 2 lakh 1,000. Lakh.
Pursuant to the directions passed by the Court of 4/1/2024, it has been duly submitted by Mr. S. Sohan that due to the deficit could be have been duly paid. Mr. Biku Swami, the learned Egyptian Advocate General, have placed before the an instruction dated 13/2/2024 issued by the additional that. And from the same, it reveals that an estimate has been prepared for the purpose of acquisition of the said land to the tune of rupees 14 crores 29 lakh 62,343.97, of which rupees 12 crores 42 lakhs 54,542.76 is have been determined as the compensation to be payable. This court has duly perused the estimate, and from the same, it reveals that the estimate has been prepared on the basis of the Land Acquisition Act 1894. A question therefore arises as to whether the compensation has to be paid in terms with the Land Acquisition Act 1894 or in terms with the Right to Fair Compensation Act 2013, taking into account the specific notification that there is a specific notification of the government of Assam, wherein it has been duly mentioned that in respect of acquisition of land under the Assam Acquisition and Acquisition Act 1964, the compensation would now be paid in terms with the Right Act of 2013. This aspect of the matter would require further deliberation, for which the matter can be listed again on
But at the first week of March, after 6.
you have urgency, you don't have.
Because they may require some time later, as it may learn time. As may learn time, they are may learn.
Hello, he wants it in the 4th of April 2020.
Maybe matter become
The learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous and accordingly. So, taking into account the above, the instant petition therefore stands closed. No interim order, huh?
Yes, Lordship, my lord. The police officer, my lord, committed, my lord, unbearable atrocity, my lord, only because, my lord, during the night time, while the petitioner was, my lord, uploading, my lord, the NRC at that point of time, it was, my lord, a very, my lord, time-bound matter, my lord. And,
Yes, what happened to the fire?
my lord, I am not aware what.
Yes, so, we have filed our affidavit and case was registered.
Huh?
Case was registered. Our affidavit. is
Case was registered.
Yes.
Then. I say money area on the case will register. Case number.
Relevant for paragraph 4. Or.
So now what has happened?
That
That
is
is 2015.
Yes, Lordship, that is instruction is not. Not
It's the matter on. It's the matter on 5th of March 2024. On which date? As per my hearing. Shall apply for. As to the present status of Howrah PS case number 54 of 2015 registered under section 447, 392, 427, 342, 325, 506, 34 of Indian Penal Code. Now what has happened? There is a disciplinary proceedings.
not. That is a.
Hello, you find it, you just get your update.
Yes.
Yes.
Right, Mr. Lordship, this petition has been filed seeking a direction to get the compensation from the respondent authority.
Why?
Lordship, there has been an assessment made in the year 2007, Your Lordship, which amounts to rupees 4 crore 61 lakh 48,840. Thereafter, number of petitions were filed, and on the last connection, my lord, page 60, the earlier assessed amount of rupees 2 lakh 98,000 98 lakh 1,380 only payable to members of Lidos Punali Pathar Parisanala committees agreeable to the committee.
So there is a direction of this court, then also they have not done it.
Yes, Your Lord. They have subsequently filed writ petitions and writ appeal. But if the first direction was given in the year 2006, Your Lordship.
So we'll have to have the Court India. Who is
Yes.
appearing for the Court India? Court India is the party.
Yes, Your Lordship. NECCIL is
Who
a
is
party.
representing for the Court India?
Lordship, senior advocate Mr. M.T. Ahmed.
His name is not shown in the cause list. They have not filed affidavit also, no?
Yes, your lordship, they have filed act.
What is their stand?
Lordship, they have filed
Why there are
another
two
petition.
petitions?
Yes, your lordship, the other petition is filed by the NEC, seeking the NEC Coal India Limited, your lordship. Seeking that order of 5/6/2015 to be set aside and quashed.
Why?
Because their main ground is
They were
like-
not heard.
Yes, your lordship.
Either-
There is no joint verification. They were not heard.
Chalo. And the matter has been taken up. The council responded. Coal India was not present. For which that in the for and as such. For the ends of justice, the matter can be adjourned to be discussed again on 7th of March 2024. A liberty is given to the commission to mention the matter for upgrading on the next.
Apply, your lordship.
What is this? You do?
The Lordship order passed on 14/11/2022. The land acquisition matter regarding the payment part.
What payment?
Lordship, the land acquisition as per the new act, 14/11/2020 order.
Yes, Mr. Barbadari, what is this type of matter?
Yes, sir. So government has not filed any affidavit. Lordship subsequent order passed on 25/4/2023. Here, my lord, what has happened? But affidavit was filed. Now, my lord, these matters, my lord, the land were acquired under the provisions of 1894 Act. And by that time, my lord, the award was passed, my lord, that new act has come in. So therefore, my lord, admittedly, it got left, entire proceeding got left. Then
This
it,
lapse or what was passed?
award was passed.
So the once the award is passed, that the award has to be
Now,
then revisit.
yes, and then at that point of time, my lord, one who arose before this honorable court, because a statement was made from the petitioner side also, their lands were taken, and my lord, the national highway stretch was already constructed. So therefore, my lord, the NHIDCL was asked to file an affidavit. NHIDCL has filed an affidavit, my lord. They have stated, my lord, that the parted parcel of land in question that was handed over to them by the PWD. Now, the Kala, on behalf of PWD, they have handed it over. And there, my lord, as per the central government guidelines, my lord, the lands are to be handed over by the state authorities. They have made a statement in their affidavit that free from all encumbrances. Now the question arises, who is going to pay the compensation? Because, and I have seen, my lord.
Compensation has not been paid
My
to
lord,
anybody.
no, nobody has. Initially,
Land has
government-
been taken.
in my case, Article number 15 lordship, part amount was under protest that was received at 7220 lordship. Then after this order, they did not file any affidavit. Then in later on 25/4/2023, they submitted that National Highway has done all this, so they are the necessary party. Thereafter, the National Highway appeared 25/4/2023 order. Then the National Highway appeared, and National Highway on 19/7/2023 filed an affidavit stating that it is paragraph number 5, page number 78. It is submitted as that though later on the land of so and so has been transferred to the National Highway by the ADCL land acquisition, Tinsukia after declaring government land for construction of bypass number so. Payment, if any, for the purpose of land compensation is to be paid by the land acquiring department. The executive engineer PWD only has no cause of action against the National Highway. Now what happened? They are shifting regarding the payment since 2015. Partly they are paid. Now everything is over. Then they have come up for the first time on 25/4/2003, making the National Highway as a party that is required to be. So National Highway was implemented, and National
Now what
Highway.
is standing on that?
Now they are stating that they have given us.
Now what is being used? Hey, Yes, Mr. T. Gokoi, you are there. Hey. Now, what is being used for that road? Is it a road now?
National highway for that purpose they've acquired.
So if you do one thing, if the state government is not paying, if the national highway is not paying, then we hold it that the proceedings have lapsed. Because as per that judgment, they have not paid any. So under such circumstances, then as per indoor water supply, even as per indoor water supply, if the amount has been paid to the maximum of the people, it is a different thing, it won't lapse. But otherwise, it is lapse. There is no tendering. Now the authorities, they don't know who to pay or whether to pay or not because the state is saying this or that. We hold that the entire acquisition has lapsed and thereby you get.
In respect of the item number 16, Lordship, isn't that due to ill health could not come and his father is expired.
What is being
Arup
done now?
Goswami's father is expired, so he could not come. In his case, about numbers of petitioners there, they have not got a single penny. And now their other part of land is acquiring. So that's why they have filed affidavit. Put our item number 16. He could not come. Junior is here, Lord.
Okay, but we do one thing that as the state government says that it is being given to national highway.
Yes.
National highway says that I'm not the requiring authority.
Yes.
So under such circumstances, we will hold that the land has to go back to you. Be happy with that. If they want, they will acquire as per the new process. We applied 366 paragraph 6 of India.
That is correct, madam, but otherwise also their affidavit, my lord, paragraph number 5, my lord, that says, my lord, I am reading it, my lord, quickly, my lord. Later on, it was decided that development of bypass will be taken by NSIDCL. Therefore, the land acquired by the state government and possessed over by the executive engineer PWD NH has been handed over to NSIDCL by Kala. It is the Tinsukia Heights, so dated 9/9/2022. The total land handed over is so-and-so. Then, my lord, it is stated that at the time of transfer of the state acquired land, no condition for payment of land acquisition was intimated, and also no information about any application or anything pertaining to compensation of the transferred land was brought to the notice of NSIDCL Kala. NSIDCL by the Kala. It is further submitted that mentioned that as per the extent guideline of the Ministry of Road Transport and Highways, New Delhi, the land resting in central state government is transferred to central government more free of cost for construction and development of NH without any liability. Since the land has been acquired, is the state government land and therefore being transferred to NSIDCL subsequently, the NSIDCL is not liable to pay compensation or for
Anyway, you see, you are not taking the responsibility to pay. Neither NHADCL is this. Don't need that.
No, my lord, what I was about to submit is that if Lordship could please to hear the PWD. PWD is not a party here because it was, my lord, taken over by the PWD.
Was the PWD the requiring authority?
Yes, PWD.
If the PWD has not made the payment,
Yes.
payment is not bothered with the requiring authority, is only bothered with the acquiring authority.
The acquiring authority
And if
is
the
there.
acquiring authority has not made the payment,
No, my lord, if perhaps, my lord, if some money has been, my lord, already been, my lord, earmarked by the PWD in this connection, my lord, that aspect
they are
of the
not
matter,
being,
that aspect of the matter
not
can
necessarily, you see, Mr. Gorbujali, that's not something to return back to them. We hold it as land. NHADCL is not bothered with the land, with the people, but also not bothered with payment. So better if the land does not, it is this land has no relevance. Because he has no business with the requiring authority.
No, absolutely.
You have acquired. You are not paid this month. And how much amount you have got? 50%.
In my,
How much amount you have got?
I got 1,92,13,660.
For how much?
That part of amount I received that as my page number 37. From that, on the basis of the award approved by the, in my page number 15, item number 15 notes it. Can you please-
Where?
Page number 37, you come. Directed to pay.
To pay what? 59.
Yes, approved.
So this was given on the month.
Yes,
Then
and the
how
challan,
much
lordship, that is there later on, page number 38.
the sum of amount payable to you, if you are willing to accept the, you should be then
Then lordship, page number 40 unit,
how
And
much you have
yes,
received?
1,92,13,655. That was,
You have received it.
yes, that I,
Then how much amount you entitled?
no, that has not been assessed, lordship. As per new act, my amount,
That is another thing.
yes, yes.
That
lordship.
is another thing.
That part.
We are
that-
not, so here it is a different, but
That
who
is-
has not, for here, this amount has already happened. Now, if you are aggrieved, you are therefore to approach the district authority, the file a reference application. This is okay, but the other matter where the person has not, you have already received the amount,
As per the new act, that is the lordship. has
It's
passed
the
order.
council.
Yes, yes.
You
that-
have
yes,
received.
Yes,
so whether you are entitled to more amount or not, that we are not concerned to that effect.
yes,
So, if you are entitled to, you have to go there.
yes, lordship. But as per the new act, that is decided by this court.
Why should this court?
No, this court has only that part of the order that my assessment, everything has been decided when the new act has been come up. When the new act is 1/1/2000, thereafter they did everything and paid me that as per the old act. The Evan, don't kindly see.
No, but the fact that the award has attained finality. Have you challenged the award?
No, not challenge.
If you have not challenged the award, how can this court override the award? Because the award has attained finality.
Against that award that I come up before this honorable court earlier, then first read petition, lordship, that kindly see, then lordship, page number 48, come to page number 48. Initially I filed that petition.
No, you have already received a part of it.
Yes.
So the question of lapsing does not arise. It is the question of quantum.
Quantum.
So quantum you have to go before the district judge.
For the DC, I filed a page number 58, lordship. I filed a petition, then nothing was heard. Then again, I come up before this honorable court.
But what about the other case?
Other case, they have not got anything.
So then we hold it, there's lapse.
Okay, my lord, so far this case is concerned, my lord, lordship may kindly come to, my lord.
Which
and
case?
This case, my lord, Lido Tea Company.
No, Lido is okay. Lido is
No,
done.
no, in Lido,
No,
there is
Lido, he has to go to the collector.
a collector, but there is a speaking order. By the deputy commissioner at excerpt 12, it is case, my lord,
48, lordship.
Case 48.
That's why
Lord-
we come up.
Before disposing, lordship may kindly see this. Case 48, because they had approached this honorable court earlier. There was the order that is so-and-so in WPC so-and-so Lido is passed by the Honorable High Court Guwahati with a direction to the respondent to pass appropriate order on examining the grievances raised by the petitioner. In pursuance of the order, there was the case record and prescribed procedure of law followed in connection with acquisition so-and-so in allegation number 47 of 9. Whereas notification under section 4.1 was approved by the government on 1910-2013 under urgency clause dispensing the requirement of 5A and the same was published in.
So this order needs to be interfered with 27. He has no business. After he has passed that order, what business does he have? Tell me.
So this order was passed in pursuant to an order passed by the Honorable
That
Court.
is the problem.
If-
How can this court pass an order?
No, no,
If you
I
start
should-
passing of these orders, that is the biggest problem. First, you are giving a jurisdiction to collector to review.
Because
He's reviewing.
in the
How can he review? There's no business.
This-
His simple question is that he should have referred it. And because of him not referring it, now the government will be liable for payment of interest. Earlier, I would have passed an order not to give the interest now. But now the government will be liable to pay. Because his order needs to be set aside, and it is because of this court's delay the matter could not be dealt with. So he'll be entitled to 9% and 15%, the government.
because this order has been put to challenge and the
Therefore,
yes.
because of that, because you see the problem arises because of this order. He didn't apply. And with due respect, this court also.
and this court order, people find it at page 44.
Huh?
Page 44. I'm just spelling it out. Malad, without expressing any opinion on the merit of the case of the petitioner, the writ petition is disposed of, providing that the Deputy Commissioner Tinsukia may examine the case of the petitioner and pass appropriate order as expeditiously as possible.
Where is that page?
There is page 44. That is what I'm reading. Because they had approached this honorable court earlier also. That was by filing WBC T493 of 2015. Whatever may be the outcome of the examination of the case,
But the acquisition was not done under the NHI Act.
acquisition was done under the 1894 Act.
Then
Now, how Kala may step in, that is also one aspect of the because Kala don't have any jurisdiction here.
Why?
No, Kala will have jurisdiction if the provisions of Highways Act has been applied to. There is no authority as
who had acquired?
the state government.
State government has
The
acquired.
state government has acquired it, my lord, that DC.
Kala has no business to hand it over.
Therefore, so the acquisition was done under the provisions of 1894 Act. It was done at the behest of the PWD. PWD was the requiring authority.
I think he's saying that it is the end of the day. Instead of flipping off the fan, flipping off the light.
So finally it is so. Now finally it is so. Now, my lord, the land was acquired by applying the provisions of 1894 Act at the behest of PWD. PWD was the requiring department. They required that parcel of the land for construction of highway. Land, my lord,
Because NHI the highway authority of has a
Yes.
that if these people would have done it to give us the land, done under the NHI.
Yes.
If that was there, I would not have to be liable to pay, taking into account that into the court schedule, it was outside.
yes. In fact, authority is a mix of everything. Now, my lord, 1894 Act applied part and parcel of the land acquired. It was given to PWD. Once it was given to PWD then hands over it to NHIDCL. NHIDCL now comes up with an affidavit says that no, we are not the requiring authority. It was handed over by the PWD at that point of time without there being any condition that we are liable to pay. And it was they have written it to the Kala.
Who is paying for the
NHIDCL RK Talukdar is there, but
Where is it?
That because of the person.
he was
Because I
there.
think we need to hear the NHI. Because NHI, if NHI is not willing to pay, then in that case,
No,
NHI revert the land back.
Yeah.
So that the deputy then takes over
Yeah.
and then tells you anything.
It is because that query ran up before my lord's mind at an earlier point of time. Therefore, my lord directed NHI that you file an affidavit. What is going on? So therefore, in
But
person,
NHAI, my opinion, is right.
Madam?
In my opinion, NHAI is right.
Yeah.
Because if it was done under the 56 Act,
Yeah.
NHAI need not pay because this was the award was passed 2015. But within 1 year, it was kept under the exemption, so it was not applied. Now NHAI they would say, why should I pay?
NHI
But
said
is NHAI willing to return the land back to the deputy? The question.
that is not spelled out in the
No.
Yeah.
When the NHAI lawyer appears, then would that
that is not spelled.
if they are asked to return the land only, then they will pinch.
Because NSI itself was not a party responsible. Yeah,
But whatever may be.
Yes.
This is an interstate dispute between you and them.
Yeah,
Why the petitioners matters
No,
to
no,
be
no, yes,
separately.
yes, correct. No one has the authority to take over any land without taking.
No, the petitioner hearing thinks that he should be, this court has to set aside the 2015.
That's taking order. Yes,
Now, once this court sets aside that, the question therefore is, the court will obviously say that the deputy commissioner ought to have made the reference to the authority. And thereupon the authority will decide. That is the only thing whether it is. Now, could this court entertain your interstate fighting?
absolutely.
Or return the land. Or return the land does not arise.
Because my guardian.
No. It's not like you're turning of the land. You're in the
Yes.
okay. For that we have to set that.
Yeah.
Anyway, we hear the NHAI from
And in the second matter also, an affidavit has been filed by the department.
but here the payment has not been made. Now the problem
Payment
arises.
is not yet.
If the payment has not been made, then
That affidavit I will, my lord, submit before.
here it comes
Yes.
to data.
We have an affidavit.
These are not matters to be taken up for safety.
Yes, definitely. Because my lord admittedly, my lord, it is very difficult. A lordship will
Yes,
understand.
No, in fact,
2015 and
these
14
matters
lordship.
fairly covered by my that judgment of his senior, I passed Sagarmal
Sagarmal Agarwal, I have it, yes.
that matter is
Yes,
fairly covered.
yes.
But only thing here, the difference is I have to set that
Now the problem, real
but
problem,
here he will be entitled because of the false.
now the real problem will arise, my lord, once my lord disposes of this petitioner is relegated to the reference court. A reference is made before the reference court. Reference court will definitely interfere, my lord, and it will, my lord, increase the quantum. Then the question will come, who will pay? That future type, my lord, that will be really a big problem.
No,
Because
the
NSR
problem will be
can-
the problem will be the deputy commissioner. The payment is to be made by deputy commissioner. Deputy commissioner
Yes.
exercises as an agent of the
Yes.
government
Now, deputy commissioner, then again, my lord,
to
because-
snatch all the buildings of the deputy commissioner, sell it.
but then that is the difficulty because deputy commissioner doesn't do it for his.
No, why
for-
should this court entertain the fight between interstate dispute between
So therefore, my lord, it was my respect for sufficient. If my lord doesn't suggest, my lord, PWC may be hard.
PWC is not relevant. You want to get out of the deputy to get him on the deputy. Deputy is not anything. If the land, in that particular land, now there is a road of the NHA, then the question will be how to specialize that.
Definitely because
Because the PWC has no business.
No,
They are too small of right. They think here it is the
definitely now that few of the matter is it will possible if my lord takes back view of the matter in the second institution. Second institution, if for a moment we hold that nothing has transpired, everything has left. So you return the money, land. Then they will be running out. But here, my lord, they have already, here it is the question of who's going to pay the money. How here we can, my lord, tangle with NSIDCL. That is my query. How to bring NSIDCL on terms here, because they have, that petition is okay, my lord. So they will say, no, it has left, so return it. They will be in real trouble there.
So that is why both the matters are taken together.
That is why, but my lord, kindly take care of my lord that compensation. At the end of
Otherwise,
the day,
at this time, this order matters have been already disposed of. Matters have been disposed of, that's it. But this matter, I'm just saying it because so that something can be leveraged to get back. So it is your thing, get hold of a deputy. Or get an additional application. I think that
I will
Or
convey, my lord, to
either
the,
additional
no, I will
application
convey
or
to the advocate
no, no.
general also.
See, what happened? Instead of you are the revenue. So if there is a additional advocate general, he represents all the department.
Yes.
So he can very well say, make the submission on behalf of the revenue as well as them. And thereby
Definitely. In fact, not only
without the PDF.
I will also try to seek the assistance of the advocate general.
So because then only the thing.
Yes, yes. Because that will be a real problem. Because I foresee that
Understood.
problem.
So therefore,
Yes.
it's so either the because I can't make the PDF be a part.
Yes, 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 yes.
Neither, in fact, in this case, my opinion, the NHI also has to.
Yes.
It's not ordered.
It's not for that. No, he is in a much better position, my lord, because he has received some amount of money. The matter will now go to refund. There is a continuity. There is no break in the chain. So therefore, he is, my lord, safe.
No, no, okay, but the thing is, therefore, I'm saying, in this case, NHI is not even required. The court right under the what about it and did it. If I was the person, I would have never done, because the moment I bring that, it will be creating this problem which is now erupted.
But in this case,
No, my lord, who is
This
going to-
problem wouldn't have arisen
because
otherwise.
we-
We are not bothered.
No, my lord, in all the land acquisition matters, my lordship is dealing with it every day, my lord. What we find, my lord, Deputy Commissioner Office on good faith, my lord, because the acquisition proposal comes from the acquiring department. Acquiring process started for some reason or other, my lord, money is not deposited. At the end of the day, my lord, it is the office of the deputy. The scheme of the act is such, my lord. Scheme of the act is such. The authority who acquires not on its behalf, but on behalf of others, at the end of the day, that authority is kept. And all money execution cases have been filed. And
You can very well. No, the reason is in then the 1984 judgment, wherein the question arose as to whether the government can challenge an order of 87, an order passed, an award passed by the deputy. A question arose. Then the Supreme Court says no, because of the fact that the deputy commissioner acts as an agent of the government.
Yes.
And as such, it cannot. Therefore, if we apply that principle out there, it can very well involve the government.
Otherwise, my lord, we can start particular proceedings because it is a public demand under the law. So this is what besides advice nowadays I am discussing. Start against the requiring department. But here, my lord, who is the requiring department? That is my lord worry.
Yeah, the
in 1/8/2022, they filed affidavit. 1/8/2022. Prior to that,
What to do?
it is on 29, so that in advocate that Vijayan does, he is an appeal, item number 16, he will also
Sounds
appear. No, lordship, because he is appearing in that particular case, and Arup Goswami's father expired
You want it on 29.
29 June, February, 29 February for the matter.
Then it comes to
But 29, my lord, some difficulty, my lord, can it be or my lord, can it be, my lord, can it be on
27, make it 27.
Can it be on, my lord, 7th of March is Thursday, my lord, if it is not inconvenient. Recorded. Seventh of, seventh.
This matter on 7th of
And so,
Oh,
final
I get it.
disclosure, Lordship, this was 2015 of on that day.
your matter would have been disposed of. I'm only concerned about the others.
Yeah, that's, yeah.
You see the judgment of, yeah.
Yes, yes.
The
Samar Lordship has clearly laid
collector's
down.
order.
Yes.
I'm not taking this additional pressure now because I'm believing taking this again that a problem with them.
My Lord, my Lord, my Lord. Oblige.